Justice he was named just more than objects.
Ready.
Adjournments, page wise. List number 1. Page number 8, seal number 38. Page 9, seal number 39 to 46.
My lord, serial number 44, my lord.
Yes.
My lord, in this case, my lord, Reliance is served unrepresented. I will take notice.
All right. Learned Counsel Shri J. Kumar D. is directed to take notice for R2 registry to show his name in the process. Read this next week.
Much obliged.
Page 10, seal number 47 to 53.
My lord, serial number 48, my lord. Serial number 48. Records is necessary. I have gone through the judgment. And 48.
Secure records.
Page number
49
At request of appellant released next week.
Page 10, sorry, page 11, seal number 54. Page 12, seal number 55 to 58. Page 13, 59 to 63.
61.
At request of appellant released after 2 weeks.
69.
Page number 14, 64 to 67. 16, sir, 60.
Number
60.
1855.
registry to list MFA along with this appeal. Released next week. Next week.
Page 14, 64 to 67. Page 15, 68 to 70.
At request of appellant released next week.
70 and 60.
Your for? At request of appellant released next week.
That is a around like this.
Then access.
Secure trial court records. All right, we listed on Monday. Yes. Before?
Recalling the order, they have made an application. Also to be disabled,
Monday? Or next week we'll have it. Tuesday.
The internal documents of the students
Release this matter on 6th February. At least. Next.
Number 2.
2.
2, Gangadhar.
Non-compliance, Gangadhara. There's non-compliance. You want to? What's the case pertains to what?
The connected is already
Legible copy ಹಾಕಿ ಅಂತ ಹಾಕಿದಾರೆ.
Legible copy has been passed.
Yes, what is it?
Complaint yesterday.
Ah,
Sir, this is the order of election. J is challenged by the petition closed down. Sir, J is the order of verification. In relating to the same claim, same party and same claim, it's already filed by the petitioner. It is already granted interim order in the earlier election, which is annexed Ch entity. Same party.
Annexure? Annexure?
Annexed Ch entity. The petition was already filed.
Page number 8.
That is the petition.
Sir, please tell me the page number.
Page number. See, page 142.
144.
No, only 42. And it's a cheap entry.
Hmm.
The still interim order operated against the respondent, which they are contested by the respondent also. Now, during the pendency of that information, the same respondent which made an application before the Assistant Commission. That is the respondent number 678. Sorry.
What is the order passed by the Assistant Commissioner?
Assistant Commissioner, that is as per annexure, please. ACSTA 23, that is an appeal filed by the same application by the respondent before the Assistant Commissioner. That order has been passed by the Assistant Commissioner. Against that, during the pendency of that proceeding, the petition filed application saying that there is a pending and order, there is a proceedings going on against the respondent. Even then, as per the annexure F 10, page 131. I filed application for including and other objection before the Supreme Court. G, the objection, annexure. H, sorry. F is the objection, G is the application for including. And during that proceedings, the Assistant Commissioner, instead of receiving the allowing the petitioner, they are not been considered in its order as per the annexure D entity, which passed and that is an anti-date order has been passed. Annexure D entity, everything passed by the Assistant Commissioner.
What is the order passed by the Assistant
That is
Commissioner?
permitting the respondent to make a necessary application again.
For what?
That is the granting of the application filed by the respondent 68226. Respondent number 6, 8, 9, 10 and 11 of this petition. Who made one more application before the Assistant Commission.
ಏನಕ್ಕೆ ಹಾಕಿದ್ರು sir? You are not, I don't understand. You don't understand the question of the court. What, you have till now, 10 minutes, you have wasted the court's time. You have not told me what is the application filed for what?
An application filed with granting the land to them.
Under which provision?
That is the under the SCST Act.
What happened to that order?
That is already decided by the High Court, decided by the Deputy Commissioner, and same order is challenged by the petition in the writ petition. In that writ petition, this Honorable Court is already granted an order against the respondent in their own petition.
And why you have filed one more writ petition?
That is the present order annexure J, which passed by the Deputy Commissioner. On the basis of the earlier application filed by the respondent, against that, the one of the claimant made an appeal before the Deputy Commissioner. In that order, the annexure J is came to first negative. For the in favor of the respondent number 6, 7, 10 and 11.
You
Same
know,
application, same.
that is granted.
Please.
Advocate.
This number 1 and serial number 3 number.
ಅದೇ ಅವ್ರ 11 ಗಂಟೆಗೆ ಬರ್ತಾರೆ ಅಷ್ಟು ಅದಕ್ಕೆ ಹೇಳುದು ಅದು ಇದು ಎರಡು ಒಟ್ಟಿಗೆನೆ ಇದಾಗ್ತವೆ ಅಂತ.
Where is the government advocate?
ಎರಡು
You are the government advocate.
Yes, sir.
Are you government advocate?
Yes,
AG or SCGP?
yes.
Take notice. No, the AGA takes notice, is directed to take notice for respondents 1 to 4. Issue emergent notice to respondent 5 to 11. Yes, what is this matter?
So that
Copies are given to you. Huh?
file is.
File is not given. Yeah. Hmm? Sorry? Oh, what entry model? Who's in position?
We are in position, as per the,
What is the extent of land?
that is 8 acres, more than 8 members. As per the petitioner's claim, 8 members are there. And each estate they are enjoyed. And budget money stands in the name of the petition.
Then why again the order is passed in favor of
That is
the,
the illegal thing made by the, polluted by the response.
take notice and make your submission, released on Monday.
And monthly, 3 months.
No.
That otherwise they are going to affect that is implemented.
You're in position,
That is the funding that.
go and enjoy your position.
Well, now they are going to create a third party led, that is.
How?
On the strength of this annexure check.
How?
Now they are entering the transaction with the third party.
On what basis?
On the basis of this order.
Which order?
That
The
is
order is
annexure
what?
check.
Order gives them title.
But anyhow, now they are entered and they are created. a third party.
Sir, records, mutation is entered,
Yes.
and on that basis they will eliminate.
Yesterday it is already.
That will not be maintainable.
On the answer.
No. You produce, you show your document of title, how you have got it.
Well, that is the order of the earlier.
It has to be examined, list on Monday.
That much is for granting appeal.
No.
Of the position and as the entry.
Sir, all that cannot be done. We have to find out what is the order, what is your history of the land and other things. This is not a regular code.
The entry model
On
was
Monday.
granted by the Honorable High Court, which is still operating against them.
Enjoy that order. Enjoy that order.
Now they are not ready to allow my earlier order by the judge. This Honorable Court is being granted.
Go and file contempt.
Now on the strength of the creation of the.
Sir, you showed me that other order already granted in your favor, where interim order is there. If they violate it, go file contempt.
Now these persons who are
Call
already.
the next man.
Still number 3.
So you want me to reject your interim order?
Of the system about the.
All right, give me. You want me to say no? You want me to say no? I will pass an order. I'm not convinced to grant right now. It has to be heard and Renagar. Make your effort, at least on Monday, you may get it.
Number 3.
Yeah.
This court issued notice to the government advocate to take the records today.
Yes, you got the records. Henry, government, you want to keep taking time like Monday. So what is the difficulty for you to get the records when already court has passed an order? What is this, some trust matter?
An application for starting a primary school was made. That said application was rejected on 3 grounds. That one, the sanction.
Get the records.
AIT.
So now you are running the school or not?
It started because of this that they are required to check down the activity.
Right? Because of?
It was started because of the anticipating this that they have not, first they rejected, appellate authority allowed on the same grounds. It was rejected by the appellate authority and directed to reconsider. On the very same ground, the DDPI rejects it. Then I file an appeal in the appellate authority, they can diametrically oppose which we have already taken. There are 3 grounds to be rejected. One, the application is not, the sanction plan is not by the local authority. That is in a KID area, and the KID Act is only the KID which can sanction.
What are the other two
Sanction
grounds?
plan by the KID.
What are the other two grounds?
The two ground is correctly for the fire clearance is in the name of the owner, not in the name of the college. Subsequently, the clarification issued by the Director of Fire Services granted the permission in the name of the petition. Third ground is that the landowners who lost the title in 1983, 82, they filed a suit before the court. And that suit came to be rejected. RFA is pending before the court. And a writ petition is pending before the court. There is no interim order. Pendency of the proceeding is taken. These are the three grounds which are rejected. Then that was challenged before the appellate authority earlier. That was set aside by the appellate authority, directed to be considered. The third respondent, once again on the very same ground, rejects. And against that, an appeal is filed that the appellate authority, very strangely, takes the view that the sanction plan, only one para 5 at page 41, that the sanction plan, the fire service, fire clearance certificate is dated 14/9/2023. And the sanction plan is 23/12/2023, which is not even the reason given in the order included. It's absolutely wholly arbitrary. That's the reason court directed them to get the records.
What
And
are,
that,
which class you are running? Which class you are running? Which
What to the base?
primary, higher school?
Primary.
Higher. All right, secure the records. Monday.
Instead of funding it,
Then at VGA accepts notice. You have taken notice
they
or
haven't taken notice. There is a direction to produce the records.
VGA to secure records? List this matter on Tuesday.
Please.
One, for non-compliance of office objection, second time. Serial number 1.
Yes, Manjunath.
The second team.
A week's time granted to comply.
Serial number 2. Guitar.
Statutory. Today.
Yes.
So you want to argue the matter today? Our counsel for the appellant submits, you do the needful today. In the course of the day. Also.
Number 3. Panchamadi.
Learned counsel for the appellant filed a memo along with the paper publication of notice having been taken to respondent number 6. Just taken out by way of pursuit service through newspaper publication. Dated 27/12/2023 in the Samyukta Karnataka newspaper of which edition? Mysore edition. Call out the name.
Sri Nandisha. Respondent 6.
Respondent number 6 is called out in the open court. There's no representation either by himself or through counsel. His notice is held to be sufficient.
Serial number 4. Ravishankar Shastri.
Counsel for the appellant has filed a memo for having taken out notice to respondent number 1. A substitute service through newspaper publication in Hosa Diganta Kannada Daily Newspaper, Mangaluru edition. Dated 14/12/2023. Respondent number sole respondent, Obrena. Respondent number 1 is called out.
R1 Nitin John.
Nitin John. No representation either by himself or through his counsel. And notice to R1 is held to be sufficient.
Bill number 5, Devi Maheshwarpa.
10 days time granted at request of the appellant. List along with MFA number.
Bill number 6, Srinivasan
In this case, my lord, 6, my lord, I am appellant, my lord. R2 is the, my lord, universal sempo, my lord. The B Samprati, Ravi Samprati, kindly be directed to take notice, my lord.
Notice to R1 is dispensed as liability is accepted by R2. Memo is accepted.
May I take notice, my lord?
What is the report? R2
May I take notice, my lord?
No, the notice is said.
left.
Learned Counsel Sri Vijay Kumar P is there to take notice for R2 registry to show its name in the cost list.
Much obliged. Much obliged.
Much obliged, my lord.
Number 7,
My lord, in this case, my lord,
Yeah, ready.
I am for the respondent ready. I am ready, my lord.
Pass over.
Bill number 8, Chandrasekhar BA.
Notice to R2. You are taking notice for 1 and 2. You are a claimant. Who are you? Appellant here. Owner. Sir, appellant either owner or insurance company or claimant.
I am neither the owner nor the driver of it. That is my contention.
Who are you before the trial tribunal? Who are you before the tribunal?
Criminal, I am taken as a owner of it.
The liability is fastened on you. Yes, you are able to hear me? Liability is fastened on you.
Liability is fastened against me and NVW is issued against me. No,
Have you deposited the amount?
no, my lord.
It's coming first time.
No, it has come several times.
Stay is granted.
It is granted me.
On deposit jewelry engaged stay work agutte. He has not deposited the amount.
No,
Where?
it is not.
Why?
It's not like it. No, it's a waiver.
All right. You are ready to argue?
Yes, my lord.
All right. Pass over. You have not been served with a copy. All right. It is next week. At request of counsel for respondent 1 and 2. So you are the claimants. Why they are not able to appoint a counsel?
My lord, in this case, caveat has been filed. And served twice copying the caveat counsel. Thereafter, the Supreme Court has directed me to serve copying the advocate who is appearing in the trial court. That has been said by RPA. The learned counsel, I called him and said, I am sending the copy. He said that he don't receive it. But he has refused it. That I filed with the acknowledgement of this counsel.
So wakalat is filed by somebody.
Caveat, not caveat.
KVA. Who's that? What is the name of that person? Huh?
Srinivas A.
This is serial number 1.
A, sir.
Where is Srinivas here? His name is not shown. Why? KVA ನೀವು copy ಕೊಟ್ರಾ? He refused to take it?
No, I went and served.
Hmm.
Again, the court directed me to go and serve it and I kept the
passed on the matter. Again, I went to his office, again I saw it, I filed the acknowledgement, will be done for, they have not done it.
You are not the owner of the
I
vehicle.
am not the owner, I produced the document also.
Who is the owner?
Some person.
You produced the B extract. What have you produced?
Passive.
So he has been relieved from this case. Caveator.
Rizwan Beg is the owner of the vehicle.
No, the caveator has been relieved. Release. You have not read the order of the court. You are at liberty to secure a copy free of cost from the registry is what is passed by this court. So you can go to the registry and take an order free of cost of all depositions, exhibits, everything. That is the order made by this court. Right, order dated 5/4/23. For any other necessary documents, if any required, like deposition, exhibit, other documents, learned amicus curiae is at liberty to obtain the same free of cost from the registry at the earliest. Counsel for the appellant and the counsel for the respondent, 1 and 2 amicus curiae are present before the court. Relist next week. We'll fix a date, get ready and argue. 20? Then we are at the first week, why 26? Argue on the second, third week or fourth week. MVC case only. I'll grant your time till 15th. Second, sir. 2 weeks, sir. All right, you take it on 19th. Get ready fully and argue the matter. 19.
Yes, in my village.
Relist on 23rd.
16th is open.
23rd.
No.
Relist after 3 weeks.
Number 9,
After 3 weeks.
B. Maheshwarappa.
My lord, I am for the appellant in the connected matter. We have challenged the very involvement of the vehicle in the accident. So last may kindly call for records and it can be disposed of.
Registry to secure records. What about notice to R1? Who appears?
I very well,
I have received the copy of the first case.
All right, notice to R1 dispensed as liability is admitted by R2. Liability admitted by
The
who?
liability is not admitted because we have disputed the very involvement of the vehicle in the accident.
Who is R1? Why you want dispensation when he is disputing liability? Sir, he is in appeal. He is in appeal. When the insurance company questions liability, please don't file dispensation. Blindly courts are accepting your memo on dispensing, and after the final argument, when the liability shifted, then what we have to do? Maybe. Why you are seeking dispensation? All right. Secure trial court records. Who appears for that? He has not yet engaged the counsel. Take out notice.
Number 10.
Purchase.
R2. No, what about notice to R2? Dispense. You are admitting liability. Notice to R2 dispenses liability is admitted, memo accepted. IA number 1 of 22 allowed delay of 38 days condoned. Pass over.
Number 11. Himalaya.
Pass over. Copy quote, sir. Copy in the how he can argue. All right. What about dispensation R1? Will dispense. You have not filed appeal. All right. Relist next week.
12. Ch-16.
My lord, a fresh matter, my lord, in this case, what happened, I made a note before the, in the cost title that original appellant died and their legal representatives are now come on record and intended to prosecute the matter. Note may kindly be accepted, my lord, and notice may kindly be issued. And he has, decision was given up, my lord, before this court. Normally just to overcome the office objection.
Note below the first title of the appeal memo is accepted.
And notice on both the IAs, my lord.
Notice on IA along with main.
13.
Girisha. Discrepancy vehicle number.
The offending vehicle, registration number is 837978 lordship.
Only that discrepancy.
Some of the paragraphs have been shown as 8378.
The discrepancy is where?
Judge,
Which paragraph?
paragraph 2, but the page number in page number 19. ಕೆಲವೊಂದು ಕಡೆ ಕರೆಕ್ಟ್ ಆಗಿರುತ್ತೆ, ಕೆಲವೊಂದು ಕಡೆ 7 8 ಅಂತ ಹೇಳಿದ್ರೆ 7 9 ಅಂತ ಹೇಳಿ ಕೆಲವು ಕಡೆ ಕರೆಕ್ಟ್ ಆಗಿರುತ್ತೆ, ಒಂದು ಕಡೆ
What is the number? What is the number?
page number 19.
What is the vehicle number?
Vehicle number is 8378.
8378. It's 6337 actually. Oh, that is tempo. 8379 is it?
78.
The correct number is
ನಮ್ಮ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಡಿಗ್ರಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಎರಡು ಕಡೆ ಟೈಟಲ್ ಡಿಸ್ಪ್ಲೇ ಇಲ್ಲ.
what is that is the objection.
Please.
Objections raised by the registry with regard to the registration number of the offending vehicle is KA 148378. Whereas in the judgment, it is wrongly mentioned at some places as KA 148379. Correct?
Please,
Correct number is 78.
8378.
That's the correct number.
Please.
You are appearing for?
I am appearing for respondent number 3 and 4 before the trial. He is not the owner of the vehicle, nor the insurer.
Objections raised by the registry is overruled, as it is not the mistake or error of the appellant.
Lordship, I filed IA to sought stay of the impugned award. Lordship, the petitioner is the officer of the BBMP and the conductor of the PBMP. Lordship, they have falsely implicated in MUVC as respondent number 3 and 4. Lordship. Now, Lordship, the learned MACP Lordship was imposed the 50% of the amount on the 3 and 4. Paragraph page number 43. 50% on the insurer, 50% on the 3 and 4.
So you are challenging that 50% against you.
Please, I am ready to deposit the 50% of the amount. Those are on the 3 and 4.
IA number 1 of 2023. And please hear the order, sir. Issue notice to the respondents. IA number 1 of 23 is taken up for consideration. There shall be stay of operation and execution of the impugned judgment and award dated 13/10/23 in MBC number 5943 of 21. Passed by the 18th Additional Judge Court of Small Causes, MACT, May Hall Unit, Bangalore, FCCH 21. Subject to the condition that the appellant herein deposits 50% of his share within a period of 4 weeks before this court.
May take it B 9/2023. In other portion, they have mentioned in the art center that date of 23 of the statement. Bottom of the art, 3/10/2023. The judgment was delivered on 3/9/23.
So what is the correct order?
Correct, 3/9.
3/9/23.
Same ಮಾಡಿದ್ರು 3/10 ಅಂತ ಇಲ್ಲಿ ಮಾಡಬೇಕು ಇನಿಷಿಯಲ್ 3/10 ಅಂತ ಇವರು ಎರಡು ಯಾವ ತರ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದು ಡಿಲೇ ಅಂತ ಆಗೋದಿಲ್ಲ.
This is a regular error committed by the tribunals. Objection raised by the registry is overruled. Issue notice to the respondent. Insurance company. There shall be stay of operation and execution of the given order dated 3/9/23 in MVC 270 of 2018, passed by the Principal Senior Civil Judge. And MACT, Mandya. Subject to deposit of 50% of the award amount within 4 weeks before this court.
Number 15. Deliver SV.
Yeah. Because it was 2 weeks time to fight paper.
2 weeks time grant to file for the request. Yes.
60, the Balakrishna Shastri.
Hmm? To whom?
R2A, C and D. R2.
You are appearing for whom? 3 to 7. So R2 is dead, is it?
B also.
R2 is there. R2.
Notice has been
B is also there.
Only there. R2B also did.
R2B also is dead.
The application, sir, 1 of 23.
So you have to take notice for R2B also. Notice to R2B ಅಂದ್ರೆ steps ತಗೊಳ್ಬೇಕ್ರಿ ಅವ್ರ ಎಲ್ಲಾರ್ ತರ ಐತ್ರಿ. You have taken to R2A, R2C and R2D. What about R2B?
Application ಹಾಕಿದ್ದಾರೆ.
R2B ಹಾಕಿದ್ದಾರೆ. Why that is not shown here?
By mistake, R2 1.
You already filed application.
B1, B2.
Already issue notice on IA. If needful is done.
Serial number 70, Krishna Nayak.
Please pull the mic down. I can't hear you.
We have compared all and they also find it.
Particular. One of 21. To 21. What is the compliance? We are not paid process fee for issuance of notice. When?
21 to 21.
There is order of dismissal. What is the order of dismissal? Then how can you do after the 10 days?
That was not. That was for compare. Based by the opposite in the unsafe. Later on 18th, we have filed an application for recall. On that day, the honorable court has directed us to comply with all. We have complied.
That's good. So there is no now objections. We have counsel for the appellant is filed IA number 1 of 2021. We recall the order dated 15/2/2021, wherein this court dismissed the appeal for non-prosecution. Being satisfied with the reasons assigned for shown in the affidavit, more specifically para number 4, this court deems it appropriate to allow the application. Accordingly, IA 1 of 21 is allowed. Order dated 15/2/21 is hereby recalled. Appeal is restored to its file. Release this matter next week. Listing the IAS number 1 and 2, along with the objections of the respondent counsel to be complied.
IA, number 18, Bharat Kumar.
Negligence and liability.
Negligence and
Liability.
you're questioning. You're attributing negligence to the right.
I'm contributing it as because you were ready.
You can argue. You're ready. Argue the matter on main and dispose the case itself. Release this matter next week. Yes. What about the respondent number 3, Mr. Who's R3? Owner of the lorry. So what is your defense?
Defense is that driver has no effective driving.
He'll be required even if it is pay and recover. A week's time granted. Needful done issue notice to R3.
19, it's Nirmala.
You have filed. Where is Nirmala, Madam? Corporation KSRTC.
Number 19. Yes, Nirmala.
Injury case. What is the amount deposited? Could you? The 50 irutte illa 75 irutte 25. What is the total amount? Objections are not filed. Not challenges on what? Liabilities question. No representation on behalf of Corporation Council for claimant is present. You have filed for enhancement. That is next week. Deal is next week. You'll come prepared for main argument. Huh? Take a date of your choice. Anyone. 9? 9ನೇ ತಾರೀಕು. 9. Inform that Madam Nirmala.
20.
Inform ಮಾಡಿ ಅವರು.
Serial number 20.
Yes, sir.
I am for the respondent claimants, my lord, in this case. I moved an application for hearing, my lord. Here in this case, 75,000 rupees, 75% has been allowed to withdraw the claimants.
Sir.
It is the insurer appeal, my lord. Insurer is opposing for the withdrawal of the amount.
Passover. He is also ready to argue. You can argue the matter.
Yes, my lord.
21. J. Marty.
I appear for the respondent number 2, my lord. There is 1108 of days of delay. False affidavit has been sworn. Award amount ತಗೊಂಡ್ಬಿಟ್ಟು ಅವರು ನಮ್ಮ ಲಾಯರ್ ಹೇಳಿಲ್ಲ ನನಗೆ ಅಪೀಲ್ ಹಾಕಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸೊ ಅಂಡ್ 2016 is the judgment and COVID but ಅಡ್ಡ ಬಂತು ಅಂತ ಹೇಳ್ತಾರೆ
Sir Suresh.
Yes, sir.
You have to rectify your video. You have blurred the, instead of background, you have blurred your face also. So as it is, I am wearing glasses. So my eyesight will go further bad.
Sorry, my lord.
Actually, I bring it to the notice of Mr. Suresh and rectified it long back.
Again, even on the last occasion also I saw this, but I thought there was some.
But for others have not made that observation, my lord, because Mr. Sripa Shastri has also made that. But that's my new system, new camera, and everything is there, my lord.
The new camera.
I'll try to rectify it, my lord. I'll try to rectify it.
Okay.
Okay. I'll change the camera.
No, the camera, your settings you have to, you have something blurred, you have blurred the backgrounds on the front portion of it. All right, so you are the claimant. We'll condone the delay, or you are saying that there's a false affidavit? You want to file objections to this?
My lord, in the copy given to me, it looks like only 110 days delay. There is a small initial is there. It is not to be seen.
All right. But copy is given to you or not given?
Copy is given to me, man.
File objections, whatever you want.
Yes, I will file it. 2 weeks time, I kindly will.
Counsels for the respondents, it's time to file objections to IA number 1. Same is granted. List after 2 weeks.
22. DM Ananda.
She noticed.
23.
And I am for appellant, my lord.
She noticed.
24.
It's also fresh matter.
She noticed.
5.
Third learned counsel for the appellate issue notice to respondent pending consideration of IA number 1. IA number 2 is taken up by posing certain conditions. There shall be stay of operation and execution of the impugned judgment and award dated 5/4/23. Passed by the additional small process senior civil judge MACT Mysuru in MVC 1227/21. Subject to the condition that the appellant herein deposits 50% of the award amount within a period of 4 weeks before this court.
26. Uday Prasad KT.
You notice.
27.
Shashidhar,
R. Shushithara.
you notice.
28. Indra Murthy M.
You notice.
29.
Veerabhadra Swami,
HP.
you notice.
30.
And dispense notice to the R1.
Notice to R1 dispensed. Liability admitted.
All.
As liability admitted by R2. Memo is accepted. Issue notice to R2.
31.
Satish. Issue notice.
32.
Gurudev. Issue notice.
33. Satish Shetty.
Issue notice.
34. Shantaj A.
Issue notice to respondents.
Bill number 35. Raju S.
Issue notice.
36. Anjula and Tejasvi.
How much you will deposit? 3%. Third Leonard Counsel for the appellant. Pending consideration notice on to respondents, pending consideration of IA number 1 on 24. IA number 2 is taken up by imposing certain conditions. There shall be stay of operation and execution of the judgment. An award dated 11/8/23 in MVC 4045 of 21 passed by third additional small causes judge and ACMM at Bangalore. Subject to the condition that the appellant insurance company deposits 50% of the award amount to this court within a period of 4 weeks.
38. KPJ Sinha.
The 1 of 24 substitute service paper communication R6. Huh? Huh?
And IA, 1/1 place.
It's issued only 2 times.
You are now you have filed IE in the person. But notice is gone only 2 times. Take once more. Now, what is the Shara? Come back as what? Shara ಏನಂತ ಬಂದಿದೆ? Refused. Refused ಆದರೆ
Insufficient address for R6. Second time.
take out notice by registered post.
First time.
Regarding the R1.
No such
Which is
person.
served on the rotary family of the R1. The
You are for R1. You take notice for R1? What is your name? Huh? SV? SV Hegde. Hegde Mulkhand. All right, Leonard Counsels. SV Hegde Mulkhand accepts notice on behalf of R1 registry to show his name in the cost list. Fresh steps with regard to R6 to be taken by way of registered post. Or only for R6 you take.
38.
How that person or Raghu can be accepted who's a family member?
90.
Yaru?
Hospitalized.
R1. Age is to?
91, 93. 91 age.
What is the material you have produced to show that Raghu is the family member? That's what is directed for you. How do we know who's that Raghu? Whether you are only received. Where is the material to show he's the family member? He's not a party. ಯಾರು ಕೊಟ್ರು? ಅಪಲೆಂಟೆ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿ ರಘು ಅಂತ ಕೊಟ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ? ಇಲ್ಲಿ ಗಣೇಶ ಫೋಟೋನು ಕೊಟ್ಬಿಟ್ಟು ಹಾಕ್ತಾರೆ, ಏನು ಇರಲ್ಲ ಒಳಗೆ. ಇವ್ರು ಇಲ್ಲಿ ಕಳಿಸ್ಬಿಟ್ಟು ಇವರೇ ಹೋಗಿ ಅಲ್ಲಿ ರಿಸೀವ್ ಮಾಡಿ ಸೈನ್ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ. These are all things happening. Take out notice once again. This is the first time or second time?
Second time ತಗೊಂಡಿದ್ದಾರೆ ಈಗ.
For R1. Fresh steps to be taken for R1. Your registered post. And so also for R6 you take. 3 times ತಗೋಬೇಕು ಅಂತ ಇದೆಯಲ್ರಿ CPCL. If the third time it doesn't happen, then we'll keep your IA pending. You can appreciate. Next.
Number 38.
There's no representation. So the MFA 5959 is connected with your case? Same accident?
Second offense is filed by the claimant. 4588 of completion. First offense is filed by one of them.
All right, we'll have it next week. We'll not file Wakala. Huh?
Either responsibility.
Correct, sir. He's not filed Wakalas. He has to take instructions. So senior is also not here. Wakala is sign. Next week, get ready and argue the matter. Take a date. All right, released on 12th February at request of counsel for respondent.
39. R. Shredhara. Serial number 39.
Shashidhara. Vijay Kumar.
Serial number 39.
Pass over.
40. NS Bhatt.
Sanmati. But you are ready? Records ಬಂದಿದೆಯಾ? Not sure. Does it come? ಎಲ್ಲಿ ನೋಡಿದ್ರಿ records ಬಂದೇ ಇಲ್ಲ. You go through the records. Request of counsel for appellant release next week.
41.
Muralidhara. Ready na? ಯಾವ್ದ್ರ ಬಗ್ಗೆ? No representation on behalf of appellant. Counsel for R1 is present. Release next week. Secure trial court.
42.
All the copies to be furnished to respondent number 2, release next week.
43. HR Renuka.
Huh? Okay. Senior is? Huh? ಹೇಳೋದೇ ಅವರು ಕೂತಿರೋರಿಗೆ ಕೇಳಿಸಲ್ಲ ನಮಗೆ. ಏನಂತಾನು ಸೀನಿಯರ್?
ಸೀನಿಯರ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆಯಂತೆ ಸರ್.
Request of appellant release next week. Who is willing to argue?
44 urgent. 45. Janak Pujari K.
Okay. Satisfied? They paid the amount? Don't case happy. Senate counsel for the appellant files a memo to withdraw the appeal. Placing the memo on record under submission. The appeal is dismissed. has withdrawn.
46. Puttaswamy C.
Ready? Huh? ಯಾರಿಗೆ ನೀವು ಮಾಡ್ತಿರಲ್ರಿ ಏನಾಗುತ್ತೆ ಅದರಲ್ಲಿ ಏನಿದೆ ಡೆತ್ ಕೇಸ್ ನೀವು ರೆಡಿನಾ ಇವತ್ತು ಬರಲ್ಲ ರಿಷಿ ಶಿವಣ್ಣಗೌಡ ಏನ್ರಿ 45 matters nobody is ready to argue. Shall I pass over or next week? Pass over no. No, ask him first whether you can argue. All right, we will have it on Monday. Council for respondent number 2 seeks time relist on Monday. Date ಕೊಡುವೆ. ಐದನೇ ತಾರೀಕು Monday ಮಾಡಿ.
47. Ramya H.
My lords, I appear for petitioner, my lords. A week's accommodation, my lords.
R1 represented.
R1.
Means so.
R1 is served. Request of appellant relist next week.
Much obliged.
Antaraj. Uttara. Passover. Yogesh.
51. Yogesh GK.
Angela Tejasvi. Passover.
52.
Okay, Somapur. Ready? 163A. Schedule. Huh? You are ready to argue? ಬರ್ತಾರೆ ಅವರು ಪಾಸ್ ಓವರ್ ಮಾಡ ಯಾರಿದು ಹನುಮಂತಪ್ಪ ಬಸವಣ್ಣಪ್ಪ ಸೋಮಾಪುರ್ he comes regularly. Okay. Regular is not regular advocate. All right, sir, I am ready to hear you. If you take a passover, let him come. If he doesn't come, I will adjourn it. ಬೇರೆ ಏನಾರ ಕೋರ್ಟಲ್ ಇದೆಯಾ ಮುಗಿಸ್ಕೊಂಬನ್ನಿ ಫಿನಿಶ್ ಯರ್ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಡೋಂಟ್ ಬಿ ಹ್ಯಾಂಪರ್ಡ್ passover
53. Rajshekhar S.
passover there is other side now are there Sabur
Yes, sir.
You are here ready yes your claimant corporation
From the common extent, two different judgments.
there is a series of who are all the others everything is filed by you.
Four is filed by the KSRTC member, two is filed by the claimant.
One by Suma and one by Abdul Sabur.
Yes.
So you are for claimant.
Clear.
So they were all inmates in the bus. Auto. So dashed against the bus. Adi, you should begin. Maybe in the meanwhile, madam may come.
In all the cases, we are challenging the liability. The liability part will be taken for the liability is on the ground judgment method.
So different judgments are passed.
Yes, no, two different judgments are passed. One judgment is regarding the three claim petition. Challenging the three claim petition.
So in this 3884,
1488 of 2021, 1383 of 2021, and 1515 of 2021 are from the common judgment. We are filing appeal of the three different claims. In that one claim petition, the other side has filed the appeal in the MFA 4809 of 2020.
All right, just tell me the MFA number, MVC and MFA. In the first case, MFA 3884.
MVC number 4 of 2019.
MVC 424 of 19. Is 3884 of 22. What about the next one?
MFA 2308 is filed by
2308
of 2020.
Come by serial wise, sir. 53.1 is filed by you. 1383.
Yes,
MVC number 80.
316 of
316 of
20.
316 of 20.
2019. 2019.
19. So that is 1383. What about the next one? 1488 53.2.
MVC 315 of 20.
315
Yes, ma'am.
of 19.
19.
That's also filed by you. Next. 1515.
1515. 3 was started.
Next 4809.
487 filed by them and challenging the MVC number 317 of 20.
317
of 2019.
So that is by claimant. Next. Two three zero eight.
2308 is filed by the claimant.
MVC number
424 of 2019.
all. So common defense in all.
The rash and negligent driver of the auto which have caused the accident. To
All right.
substantiate my claim about
First matter. 3884, in which he is the opponent. You are opposing that.
complaint marked as exhibit X1.
The case of injury or death.
Case of an injury.
All other cases are death.
Yes, sir. One is the death of a fetus.
Yes.
Yes, sir. The Swiss terminal, the auto of overloaded trial passengers, which they themselves have been admitted in the complaint that has been filed by one of the persons, which is evident for the exhibit E1. The court did not place any reliance on that document, only placing reliance on the charge as
So all the cases, they were passengers in the auto.
auto. Total 12 passengers in auto.
So the owner of auto is made a party.
Yes, sir.
Liability is fixed on.
Yes, sir.
Nothing on the owner of.
Nothing on why the liability was fixed by was that the charge sheet and the evidence of the PW both were against the SRTC. Hence the liability was charged on the
So no FIR, no charge sheet against the auto.
FIR has been filed against the auto driver, both against the taxi driver and against the driver of the auto. And the charge sheet was filed against only against the care. And you permitted to read the exhibit even the complaint of the
You want to read what?
exhibit P1
What is that?
complaint.
Read it. Is there records with them? Okay.
Exhibits.
P1. So in this case, 1 lakh is awarded. Huh?
It is awarded.
Globally. Yes, you want to read P1.
Yes, exhibit P.
That is FIR. Huh?
Complaint exhibit P1.
1A.
1A.
Sorry.
ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಐಸ್ ಕ್ರೀಮ್ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ದಿನಾಂಕ 17/2/2018 ಬೆಳಿಗ್ಗೆ 8:30 ನಾನು ಐಸ್ ಕ್ರೀಮ್ ವ್ಯಾಪಾರ ಮಾಡುವ ಸಲುವಾಗಿ ನನ್ನ ಬೈಕ್ನಲ್ಲಿ ಹ್ಯಾಂಡ್ಫೋನ್ ಬಂದಿದ್ದೇನೆ. ಹ್ಯಾಂಡ್ಫೋನ್ನಲ್ಲಿ ನನ್ನ ಬೈಕ್ ಸಂಚಾರ ಮಾಡಿತು. ಆದ್ದರಿಂದ ನಾನು ನನ್ನ ಬೈಕನ್ನು ಹ್ಯಾಂಡ್ಫೋನ್ನಲ್ಲಿಯೇ ನಿಲ್ಲಿಸಿ ನನ್ನ ಹೆಬ್ಬಾಗಿಲಕ್ಕೆ ಗ್ರಾಮಕ್ಕೆ ಹೋಗಲು ಹ್ಯಾಂಡ್ ಸರ್ಕಲ್ನಲ್ಲಿ ನಿಲ್ಲಿಸಿದ್ದು. ಗಾಡಿಗೆ ಆಟೋ ನಂಬರ್ A45 8 ಆಟೋ ಹತ್ತಿಕೊಂಡು ಸದರಿ ಆಟೋದಲ್ಲಿ ನಮ್ಮ ಗ್ರಾಮದ ವಾಣಿ, ಸರ್ವಮಂಗಳ, ನಾಗನಾಯಕಿ, ಪ್ರವೀಣಮ್ಮ, ಮಂಜುಳಮ್ಮ, ಸುಮಾ, ಚಿನ್ನಸ್ವಾಮಿ, ಹುಲಿಕಾರ ಗ್ರಾಮದ ಅನುಪಮ, ಮಹಾದೇವಮ್ಮ, ಹುಲಿ ಗ್ರಾಮದ ರಾಜಶೆಟ್ಟಿ, ದಿನ ಕೆಜಿ ಹಳ್ಳಿ ಗ್ರಾಮದ ಪುಟ್ಟಿ ವೆಂಕಟಮ್ಮ ಇದ್ದೆವು. ಒಂದು ಆಟೋ ಚಾಲಕನು ನಮ್ಮನ್ನು ಕೂಡಿಸಿಕೊಂಡು ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆಗೆ ಹ್ಯಾಂಡ್ ಪೋಸ್ಟ್ ಅನ್ನು ಬಿಟ್ಟು ಹೆಬ್ಬಾಗಿಲಕ್ಕೆ ಗ್ರಾಮಕ್ಕೆ ಹೋಗಲು ಮಧ್ಯಾಹ್ನ 12:40 ಗಂಟೆ ಸುಮಾರಿನಲ್ಲಿ ಹೆಬ್ಬಾಗಿಲು ಗ್ರಾಮದ ಕೆರೆ ಹತ್ತಿರ ಇರುವ ವಿರಾಡೇಶ್ವರ ದೇವಸ್ಥಾನ ಹತ್ತಿರ ಹೆಬ್ಬಾಗಿಲ ಗ್ರಾಮಕ್ಕೆ ಬೆಕ್ಕಿಹಳ್ಳಿ ರಸ್ತೆಯಿಂದ ನನ್ನ ಆಟೋವನ್ನು ಅತಿ ವೇಗವಾಗಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದರು. ಆಗ ಆಟೋ ಹಿಂಭಾಗ ಬಾಡೇಹಳ್ಳಿ ಕಡೆಯಿಂದ ಹೆಬ್ಬಾಗಿಲ ಗ್ರಾಮದ ಕಡೆಗೆ ಬರುತ್ತಿದ್ದ A09 F/21 ಕೆಎಸ್ಆರ್ಟಿ ಬಸ್ಸಿನ ಚಾಲಕನ ತನ್ನ ಬಸ್ಸನ್ನು ಅತಿ ವೇಗವಾಗಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಬಿಡಿಸಿಕೊಂಡು ಬಂದು ಆಮೇಲೆ ಹಿಂಭಾಗದಿಂದ ಡಿಕ್ಕಿ ಹೊಡೆದನು. ಆಗ ಆಟೋ ರಸ್ತೆಯ ಎಡಭಾಗಕ್ಕೆ ಬಿಚ್ಚಿಕೊಂಡು ಆಟೋದಲ್ಲಿದ್ದ ನಮ್ಮ ಗ್ರಾಮದ ವಾಣಿ, ಸರ್ವಮಂಗಳ ತಲೆ ಪೆಟ್ಟಾಯಿತು. ತೀವ್ರ ರಕ್ತಸ್ರಾವವಾಗಿ ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತಪಟ್ಟರು. ನನಗೆ ಎಡಭಾಗಕ್ಕೆ ಎಡ ಮೂಳೆಗೆ ರಕ್ತಸ್ರಾವವಾಯಿತು. ನಾಗನಿಗೆ ಆಟೋದಲ್ಲಿ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದ ತಲೆ, ಕೈ, ಕಾಲುಗಳಿಗೆ ಪೆಟ್ಟಾಗಿ ರಕ್ತಸ್ರಾವವಾಯಿತು. ಈ ಅಪಘಾತಕ್ಕೆ ಬಸ್ಸಿನ ಚಾಲಕಿ ಹಾಗೂ ಆಟೋ ಚಾಲಕರಿಬ್ಬರು ತಮ್ಮ ವಾಹನಗಳನ್ನು ಅತಿ ವೇಗವಾಗಿ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದು, ಕೆಎಸ್ಆರ್ಟಿಸಿ ಬಸ್ಸಿನ ಚಾಲಕನ ಅತಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಬಸ್ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಆ ವೇಗ ಹಿಂಭಾಗದಿಂದ ಡಿಕ್ಕಿ ಹೊಡೆದು ವಾಯಿತು. ಬಸ್ಸಿನಿಂದ ಪ್ರಯಾಣಿಸಿದವರಿಗೂ ಸ್ಥಳಕ್ಕೆ 108 ಆಂಬ್ಯುಲೆನ್ಸ್ ಕರೆಸಿದ್ದು. From the complaint is clear, evident is action negligent driving on both department, SRTC and department. Second is that where auto was overburdened. One auto, if the car passengers are traveling one auto, then the control over the auto will get affected. On that reason, the accident has been happening. But both in all the cases, the trial court has not considered this aspect.
But the accident has happened when the auto was in front and buses come from behind and hit him. Oh, then what is your statement?
My statement is that the auto who are traveling in the fashion negligent manner, he was the one who took the bus and hit the bus, I think, from the left side of the bus.
That is not forthcoming.
Not working, but we have taken that stand in the.
You may take so many stands.
Yes, ma'am.
The complaint which is given, and whether if that is disputed and in the investigation conducted by the police while filing the charge sheet, they have let go the auto.
They didn't take stand. After investigation, they have said that the accident has taken place by the last case. But they didn't take this statement of this complaint.
Second is that, my lord, I had produced the,
So that is maintained even by the tribunal.
yes,
Tribunal has not taken different opinion.
they did not consider this exhibit, my lord.
All right, no problem. If the charge sheet has absolved the auto rickshaw driver, the tribunal has not taken the auto rickshaw driver to be negligent.
They said that on basis of the tax. Right. Auto driver.
Hmm.
Second condition is that, my lord, the paper which was published in the newspaper on the next day of the accident, which is marked as exhibit R1.
Newspaper publication.
Newspaper publication that the rash and negligent driver of the auto driver which are caused the accident.
So we have to go by the press. Decision.
Relying
Okay. Newspaper ಏನಾರ ಆಗ್ತವೆ.
exhibit R1 is the current question R8.
Huh?
Exhibit R1 is the newspaper.
All right.
Current question is marked as exhibit R1A.
Okay. What happened to the criminal case? Will convict because of death case. They got convicted only. When you are arguing such matters, you should know what happens in the criminal case. I don't understand why the MBC lawyers don't bother about the criminal case in such matters. When you are trying to shift the liability on the auto. Admittedly, auto was carrying more than Mate. As per the Motor Vehicles Act, how many you can carry? All right. Yes. What else? How many he was carrying? 12 passengers. Yes, that is your first point. What is the next point?
Second is that, my lord, the bus was, second difference is that, my lord, bus was about to stop in that place as there was a bus stop, which I have been, the driver of the bus driver has been examined in the case and he has been affirmed by the statement that he was about to stop the bus in the bus station at the request of the passenger. At that time, the auto driver drove the auto engine rash negligent manner and the bus. That's the second difference on the liability.
That's all. Only these 2 points.
Legal permitted past judgment. Extra passengers in an auto confers 20% liability on that next part. Paragraph number 7. This case regarding the bike rider.
This is triple riding case, I think.
He was carrying extra passenger.
I have not agreed with this judgment. Yesterday, it was relied for contributory negligence. I have not agreed with this judgment.
I'm not payment.
Yes.
And carrying the compensation of the quantum of compensation MBC number 315 of
ಇದರಲ್ಲಿ ಹೇಳ್ಬೇಡಿ ಇವ್ರಿಗೆ. The other case, they probably will counter your argument. In his case, he will counter. This is a global compensation of 1 lakh awarded in that MBC 424.
Trial has failed to take into consideration that we are paid 50% because it has an increased compensation in that case.
ಕೊಟ್ಟಿದ್ದೀರಾ? That is not considered. But where have you stated it that you have paid and where is the judgment? In the order, is it mentioned?
In issue number 3, internal page number 17, internal page 9.
In the admission of the petitioner, the respondent number 2 has paid the interim compensation of 50,000. In this regard, it claims that the respondent number 2 is not entitled to deduct that 50,000.
Yes.
If we calculate the complete medical from exhibit 362B22 stand for 22,767, but they have given a compensation of globally 1 lakh. They have not taken any basis for the awarding compensation of this 1 lakh. That is the other amount.
All right.
And third is that other evidence cannot be taken because he did not make the evidence of the patent problem.
No, but disability is not given. Whether doctor is examined.
Doctor has been examined, but the doctor who has been treated has not been examined.
Is it really the doctor? There's nobody examined here.
Nobody examined.
What the?
The doctor.
Doctor Madilwal. There is no doctor, no disability. And that's why global compensation is. What are the injuries? All right, you argue. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ? Where are you reading? ನೀವು ಸುಮ್ಮನೆ ಹಂಗೆ ಓದ್ಕೊಂಡು ಹೋದ್ರೆ ನಮ್ಗೆ ಹೇಳ್ದೆ ಎಲ್ಲಿ ಓದ್ ನೋಡ್ಬೇಕು ನಾವು. You have to take the quote along with you when you read anything. Which para? Para 10. It is our evidence.
In the evidence, you have accident seen as years particularly and in this regard, here referred to at the date upon the home certificate as exhibit B1 during the classification of the conducted on the of the certification specific with regard to the nature of the particularly the right to indicate on the part of the developer. The suggestion denying and inspection compensation funding and the nature of the treatment and the suggestion about the rights and activities of the driver of artwork and in order to prove that the respondent has determined that the developer playing as the order was getting the experience and that is evidence there was no rash negligence on the part of the action. According to the rash negligence of the artwork. In support of this evidence, he has produced newspaper R1 and the exhibit R1A during the course of for having filed the charge has been the suggestion about his right against and denying the use of the artwork that has been incorporated in the material of the the entire particular there was the first injury. He is right against the artwork for the permission to have by taking the definition of probability and in the case of the
charge sheet is filed against auto driver. Huh?
Charge sheet is filed against the auto driver by taking
Motor Vehicles Act code.
Distribution of consider opinion that the You have certain previous particular to that they will come to us. Appending reverse by level, hence they are issues of
Hmm.
Fracture of para 14.
Yes.
Fracture of right lateral right frontal display and initially treated at government hospital. As a people will be continuing the follow support of the the particular produce as also in the evidence of the facility to the aspirin produce in the spent sufficient numbers of medical medical bills of 767. In the case of not entering not treated doctor nor produced supporting doctor having the one certificate and medical. On that is the rejecting is the admission of the producer, the homes are agreed and no documents are thereby there is no question of people are in the federation not exactly for consumption of various and she is entitled to a local company. For that reason, one night. But here, subsidy, education.
Read exhibit P4. P4.
Confusion on overhead with multiple population and marketing over the yes that calculated usually or R for on even one PM and one PM insights. Then right chart effect of R shows our region. This is referred to in seasons. Injury number 140.
All right. How many days you are inpatient?
Inpatient for
Admit ಆಗಿಲ್ಲ ನೀವು ಬಿಟ್ಟು. You are not at all admitted. You are not at all admitted. Are you admit? Were you admitted? Tell me where. What were you working as? What is your age? So you are agreeing with that?
from 1982, 2082, 1 month in 2019.
ಎಲ್ಲಿದೆ?
In the application present are checking full government. This Dr. Patel, orthopedic, yeah, was given.
Yes. That's all. As far as the others. So your argument is the same in all cases.
On the liability.
No, no, whatever you have argued now, in the case of injury of Mr. Sabur's client, Putta Venkatamba, he sustained minor injuries.
Yes, not. You did not examine the treated doctor.
All right. So what about other death cases?
It is not connected with liability. As far as NBC number 315 is concerned, I have actually contact with Indian case.
315 ಅಲ್ಲಿ
The death of fetus, they have ordered the compensation of 2,50,000 by the order of by the decision of the Supreme Court and the decision bench of this honorable. Only 2 lakhs may be granted in the case of death of fetus. And we will permit.
ಕೊಡಿ. So fetus rate is fixed as 2 lakhs rupees.
Apex court judgment
In which judgment?
Apex court judgment.
Para number?
9.4.
This is in the case of Shiv Kumar. Vendalal. Let's read para 9.1. How many months pregnancy was it?
In this case, may not, in our case, 9 months.
9 months. It was due for delivery. So in your case, for the fetus, how much is awarded?
Relying on the Supreme Court judgment, division bench of this honorable court has passed judgment. In that particular case, also the 2,50,000 was awarded to the death certificate. It was decreased to the 2 lakhs in that case also. In that other than paragraph 11 question is paragraph number 7.
7. 7.
7 please. Paragraph.
Where is that judgment of the Kusuma National Insurance? Where is that judgment of the Supreme Court National Insurance Company? and Kusuma and another. In that 2,50,000 is awarded.
Relying on that, they are court and awarded 2,00,000. By seeing the recent judgment, Supreme Court reversed the judgment and the plan, the which of is on the reversed the judgment from 2,50,000 to 2,00,000.
Where is that?
Paragraph number 11.
Para number?
11.
Oh, that is the reliance made in the case of that Shiv Kumar.
Paragraph 10.
Huh?
Paragraph number starts from paragraph number 10.
Where is the awarding of 2 lakhs? Where is the awarding of 2 lakhs? Huh?
Paragraph number 15.
15 to 17. ₹1 lakh for fetus. So the price of a fetus is ₹1 lakh. What, sir? We have no value for human life. You don't even get a pet animal for that much amount. 3,000 and 1 lakh. That is in the other death case. Who has to answer this? Suma, is it? Madam Suma. Let her come. We pass over the matter. That's all your arguments. All right, we'll pass it over.
Case number 54. Vinay, yes.
Again, opinion, citation is relevant facts.
Pass it.
Fifty-five, maybe Sidramaya.
Hmm. Working as assistant engineer. Section engineer. Ah. What was the salary? 1 lakh. Exhibit. What is the exhibit? Inpatient.
For 48 days. First instance, 14 days. From 1860 to 2018 to 174018. Second from 270 to 2018 to 170. For 30 days. Again for 18 days from 180 to 2018 to 15.
What is the age?
Age is 55 years.
Hmm.
Two aspects, is for pain and sufferings. 20,000 actually, but it not awarded as on the rest. Was medical evidence, complete compensation. And here for 48 years.
So there's only one petition appeal is filed.
No,
So that is in the case of
yeah.
the husband. That is a husband.
Madhavi is also, it's a different test. Also from the is. The premise that's conscious. 7,268 is the medical test.
Where is the chart of this Jairam?
Page number.
Chart ಮಾಡಿಲ್ವಾ? Not made.
I have extracted in synopsis. In the page one of synopsis.
Ah.
The total inclusions composition and thing. Unless was medical expenses paid over. Was payments of people. The fracture of tibia and other claims.
Pain and suffering and medical expense.
Medical.
ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು. So even according to you, there is no disability. Examine.
It is not intended for the future loss.
So pain and suffering amenities, later period.
And 48 days a year.
EL.
And very complete medical risk for the reason that we have produced all the original medical risk. We are not, must be.
ಎಷ್ಟು amount?
48,000.
Which is that?
47,268.
Where is that? Which exhibit?
P31. I was certified.
P31. Salary certificate.
Medical bills. Page number 139.
Records ಇದೆಯಮ್ಮ. ಕೊಡಿ. Yes, are you agreeing with this, Mohan? It's a handwritten one. Where is that proper bill for 43,000?
Eight bills were produced.
From exhibit?
It is the lost bill. Yeah. totalized.
ಇದು ಮಾರ್ಕ್ ಆಗಿಲ್ವಾ ಎಕ್ಸಿಬಿಟ್?
All individuals were marked as exhibit B30.
How can there be a difference?
Requirements are exhibit B30, so prescription is exhibit B30.
ಅದನ್ನ ಟೋಟಲ್ ಮಾಡ್ರಿ ಅಷ್ಟೇ.
ಮಾಡಿದ್ರೆ last page.
Sit with him and find out if it is correct. What is that?
Last page will be total. It over.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? You can see this. Because medical bills actual, you will have to give.
It's 48 days inspection.
So 48 days you are inpatient. That also you then, Mohan. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. So one is that medical bill. Second is inpatient of 48 days. Huh? ತಗೊಂಡಿದ್ದೀರಲ್ಲ EL.
After retirement, you will pay after 48 days.
EL is encashable leave. So on those grounds only, go through it, let him go, assist him. Masu. Serial number 56. Issue notice. Move ಮಾಡಿದ್ದಾರೆ ಸತೀಶ. Issue notice. Syed Abdul Zapoor. ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಅವ್ರದ್ದು. ಪಾಸ್ ಓವರ್ ಇದೆ. ಫ್ರೆಶ್ ಮಾಟರ್. Okay, then issue notice.
Pass-through matters. Serial number 2.
ಬೆಳಿಗ್ಗೆನೆ ಹೇಳಿದ್ರಲ್ಲಮ್ಮ. Ready to argue is what your colleague said.
State statutory deposit.
Deposited the amount.
Is the only office of sections statutory.
Learned counsel for the appellant files a memo for having deposited the statutory amount of rupees 25,000. Stop. Third learned counsel for the appellant issued notice to the respondents. Orders on IA number 2 of 23. There shall be stay of operation and execution of the judgment and award dated 25/7/23 in MVC 617 of 20, passed by the senior civil judge and additional MACT at Kiriyur, Chitradurga. Subject to the condition that the appellant herein deposits 50% of the award amount within 4 weeks before this court on the date of receipt of copy of the order.
Serial number 7. Vinodaya. V. Vijay Kumar. Serial number 7.
Vijay Kumar. Sir Vijay Kumar. New matter. ನೀವು ಹೇಳೋದು ನನಗೆ ಕೇಳಿಸಲ್ಲ, ಅಲ್ಲಿ ಇಲ್ಲಿ ಕೇಳಿಸುತ್ತೆ ಅವ್ರಿಗೆ. You have to be little fair to your colleague who is on the VC. 30/11/2018.
Both months of leg.
Age.
Age is 25 years. Is a 10 factor. Compound fracture of both months of leg. After actual fixation and Naval was operated, was admitted for 3 occasions for 5 months.
5 months.
5 months.
Inpatient.
Patient, 3 occasions. Duration of admission is 18 days. 18 days. 4 days, 3 days, 5 months.
18 days or 80?
18.
18 days.
Duration is 5 months. But after disability to whole body 21%.
21%. Error?
33. Removal of complaints was estimated for 20,000. And convention at the
Huh? Conventional hit. Why conventional hit?
Convention at 5,000.
The case of injury.
My lord, one submission, my lord. Is it my case, my lord?
Yes, sir, your case only.
My lord, I am in portal number 22. I am on my legs in the case. Another 5-10 minutes, my lord, that matter will be over. Please, my lord.
Loss of amenities 15,000 is given. Medication is 15,000. You know, the medication, future medical expense. What the doctor has said? Doctor level. Yes, so what is there? 15. So that has to be marginally increased. Laid up period kotilla. What was he working as? What is the income? Huh? No, what is the income taken by the tribunal? Correct. What have you produced? Notarized copy of the driving license. What does it say? Huh? Real P8. Exhibit P8. Now in case. Now, what is written there in the driving license? Which vehicle? Not available. License is not available with you. How you come so well prepared for your case to argue? Your client is dependent on you and he has trusted you. Full faith that you are going to do justice to your client. ₹1,000 here and there is going to make a difference to him. May not be for you. Okay. Is it not your duty to see what is Exhibit P8? Tribunal has not agreed with you. Tribunal has taken income at 11,000. You want this court to take higher income than the chart, but you don't have DL with you, which is produced at Exhibit P8. The sorry state of affairs, Mr. Counsel. Because of the negligence of the lawyer, your client is going to get lesser compensation. True. The records with you, why are you in such a great hurry to argue the matter? Why are you in such a great hurry? Now, the disability is at S2. Tribunal has taken 11,000. 12,000. What is the chart value? 12,500. What's the multiplier? 18. All right, let Kumar argue. One of the case today is going through. I don't understand why. Yes. Madam, you are ready to. Where is you are in the batch of matters? No. Satur Yar Suma. Call the next case.
Serial number 10. Vijay Kumar, please.
She is ready. Pass over.
Serial number 20. It's a visual way.
Yes. Mr. Latur Suresh. Yeah. We disposed of even one case since morning. dismissal ಬಿಟ್ಟು. ನೀವು ಅವ್ರು ಬಂದಾಗ ನೀವಿರಲ್ಲ, you are available in the morning, you are ready ಅಲ್ಲ? There is Suresh Latur. Pass over, sir. Mr. Rushvendriya. ಆಮೇಲೆ ತಗೊಳ್ತೀನಿ. ಅವರೆಲ್ಲ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. All right. 2:30.
39.
Put your number, put. Registry to list MFA number so along with this appeal. Secure trial court. Below ideal, right?
Number 50.
ಐವತ್ತಾ?
About 35 years. Actually, it's 2018, which is 2018. Income has been taken at 7,080.
Yes. Age.
Yes, 35 years. 35 years.
30. MACT income ಎಷ್ಟು ತಗೊಂಡ್ರು?
7,080.
7,080.
80.
ಅದೇನದು?
Wages, daily wages ಅಂತ
ಹಾ.
The rural employment can be schemes. Then about per day of 276.
Minimum wages. Is it minimum wages on the basis?
Minimum wages.
But here, he's a coolie, eh? Coolie. Chart value ಎಷ್ಟು ಬರುತ್ತೆ? ಹೌದು. Any disability?
Doctor assessed at permanent disability at 58%. Patient has 12% disability to right upper limb and 26% disability to left lower limb. Tribunal has taken 12%. He ought to have been taken the disability at 38%.
Read that paragraph of the reasoning.
Para 13 million. Para 13 of the judgment, he pays 19. Loss of future income, the petitioner was earning 7,080 per month, 84,960 per annum. and she was sustained functional disability of 12%.
La, adalla, come to the doctors where the reasoning is with regard to particular limb. That is, I think at page number 17 or 16, it may start with. Coolie work, last page number 17 on top, doctor 38% as per.
Compensation. The patient claim an amount of 2,50,000 medical expenses and medical are marked as activity 9. The medical is produced by the petitioner amounting to 2,66,636, hence is entitled to 2,66,636.
Yellow otta Where are you reading?
16.
To number 2 or para 10. Fracture of shaft of the
Coming to the aspect of assessment of compensation in respect of petitioner, Neelam alias Lakshmi, the examiner to be stated that she sustained multiple fracture and injuries, fracture of shaft of femur bone, fracture of right clavicle on the right temporal EDH, grazed abrasion over both wrist, lacerated bone deep over right leg, multiple grazed abrasion over face, and abrasions all over the body. Immediately after the accident, the petitioner was shifted to Angkor Government Hospital and then shifted to Kaveri Hospital, Mysuru, where she took treatment as an inpatient and she undergone surgery and implant was fixed to her femur bone and clavicle bone and the skin grafting was done. And further she was stated in her evidence that she was spent more than rupees 4,50,000 towards medical and other allowances. Prior to accident, she was well and healthy, working as a coolie. Now she was getting 50,000 per month. The P5 home certificate issued by Kaveri Hospital, Mysuru, goes to show that patient has sustained one multiple grazed operation all over the face, CT head, right temporal EDH, fracture of clavicle middle of the right side, fracture of shaft of femur left, grazed abrasions over both wrist, both ankle, lacerated wound of 3 to 5 cm, and bone deep over right leg. The injuries 1, 2, 3 are previous injuries. 4 and 5 are simple in nature. The petitioner also examined Dr. H.S. Manjunatha Bhargava at PWD and he deposed in his evidence that he has examined the petitioner on 27/2/2018 and on examination he found following injuries: right temporal EDH, fracture clavicle middle 1/3, right, and fracture shaft of femur left, and he has a disability of 10% to right upper limb and 26% disability for the lower limb, and in total he assessed the disability of the petitioner as 38%. As per exhibit P10, period 2 in his evidence stated that he has not issued disability certificate to the patient, but he has produced the disability certificate before the court. As per exhibit P10, the petitioner in her evidence shows her age is 35 years. And the home certificate exhibit discloses the age of the petitioner as 35 years. Therefore, the age of the petitioner on the date of the accident is taken as 35 years. And the appropriate multiplier applicable for the age group is the petitioner in the petition stated that she was working as coolie and earning an amount of 15,000 per month. But the petitioner has not produced any proof of income in the absence of proof of income. The income of the petitioner is to be determined on the basis of the minimum wages payable to an unskilled labor. Therefore, the notional income has to be determined on the basis of the minimum wages payable to an unskilled labor in February 2018, the year when the accident occurred. In the decision reported in 2018, 18 SCs.
All right, Ms. Shantaraj, how many days inpatient ಆಗಿದ್ರು?
9 days.
9 days. 12,500. The medical bills, actuals is awarded at 2,66,000.
2,60,000.
Pain and suffering amenities ಕೊಟ್ಟಿದ್ದಾರೆ. Future income will change. Attendance charges 5,000 is given, but we'll add another 5,000.
These fractures. And after is assessed upper limb and the lower limb. In all 38%. Therefore, 38% after have been taken. Various of these also awarded and also community is also awarded 50%. Therefore, only after the class of later prepay 14,000, that is 7,000 and out and that will also make the not increase to take it for the family. On the rest of these
Yes.
Here the underwent surgeries, surgery, craniotomy and EDH evaluation. And orange is the locking plate and screws for right clavicle, interlocking mainly for left femur. Both has been interlocking the nail has been fixed. Therefore, injuries sustained by her, we got to have taken.
Who has to tell that?
Doctor.
Neither you are a specialist, nor I am.
Doctor stated.
Where he has said.
Doctor stated.
No, what was the problem for him to say total body disability?
Yes.
ಹೇಳಿಲ್ಲ.
Right shoulder abduction, rotation painful. Elbow, FFD, 10 degree further reflection, good way. Hand grip, 4/5 right side. And unable to sit cross legs, squat and walk on uneven
The
surface.
standard is unable to sit, to stand, to walk, to climb stairs, lift weights. These are all
According to
standards.
her, what patient is a fully by profession. Considering the above disability, patient had 12% disability to right upper limb and 26% to left lower limb. And he has not assessed, he has a disability certificate is also produced and marked as a P10. And he has question of taking 1/3 in all cases does not arise. Nature of injuries. You have to look into nature of injuries.
ಇದೆಯಾ disability certificate ನಿಮ್ಮ ಹತ್ರ?
Exhibit fiction. ಒಳ್ಳೆ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ
Disability certificate ಇದ್ರೆ ಕೊಡಿ ನೋಡೋಣ. Whether he has explained in detail. See, these are all things which the doctor has to specifically state. How the tribunal and either you or me can know. This is ಅವ್ರು ಹೇಳಿದ ಮೇಲೆ based on what he says, we can make an assessment.
Doctor has not been stated with regard to the whole body disability. He has assessed the disability to the upper limb and lower limb to an extent of 38%. That ought to have been taken.
Fully.
Yes.
Then in all cases, we have to do that only.
Yeah. Medical.
26% disability to left lower limb.
Yes.
There is no amputation, there is no statement that he absolutely cannot use his left lower limb.
Right temporal ADH.
I don't know what is that EDH. Standard method calculate ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ this will go haywire for each and every case. So that is why the doctor should properly assess the disability in their statement by saying that he is absolutely incapable of performing any activity due to the head injury or incapable of doing any activity from the lower limb, cannot lift absolutely from the upper limb, coolie, or a person who's working in a desk job. ಅವ್ರಿಗೆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿರ್ತಾನೆ ನಮ್ಗೆ ಗೊತ್ತಾಗತ್ತೆ. So when such report is not there, then the tribunal will have to discount 1/3 for whole body. Correct.
ಯಾವ ತರ ತಗೋಬೇಕು ಅಂತ ಏನು ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿಲ್ಲ. ಕೋರ್ಸು ಇನ್ ಆರ್ಡರ್ ಟು ಗ್ರಾಂಟ್ ಈಗ ಕಾಂಪನ್ಸೇಷನ್ ವಿಲ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಓನ್ಲಿ ಒನ್ಸ್. Repeatedly it will not be granted.
Correct.
So adequate compensation has to be granted.
All right, you show me, you have produced photographs. ಎಲ್ಲಿ ಗೊತ್ತಾಗಬಹುದು? How do you see, unless you provide the material, how you expect the tribunal or this court to believe your version? I'm not saying, I'm agreeing with you that we cannot make a blanket rule for 1/3. Even if a person like a driver or who was not able to do anything with his right leg, he won't be able to drive. It's not necessary to just take 1/3. We can go by what the doctor says of 26%. But where is the material? Adana, you conducting the MVC cases by the lawyers in the tribunal, if they understand this aspect, each one will do their job. There, the 95% of them don't know.
Yes, certainly that's what
95% of the lawyers don't know how to lead evidence, what is to be produced. Mechanically, they will dump some papers.
sometimes which has been adverse to them, they will produce that.
ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ನಾನು ಹೇಳೋದು ಅದನ್ನೇ 99% advocates ಇಂದ ಕೇಸ್ ಕೊಡುವಂತದ್ದು ನಾನು.
Only one advocate was accepted. Fortunately, you can't saddle negligence. Yes, we'll take it at 13% instead of 12. Because even dividing by 1/3 also comes more than 12.6%. It should be rounded off to 13%. It is 1 o'clock. This is the first matter I'm disposing for the day. Nobody is arguing the matter. If one is present, the other one is absent. The appeal is preferred by the claimant, challenging the judgment and award of the 4th Additional District Sessions Judge Mysore in MVC 1469, dated 19/2/2020, on the ground of inadequate and meager compensation. The claimant was a pedestrian standing in front of his house on 26/2/2018, during which time a vehicle bearing registration number KA45M3044, driven by its driver in a rash and negligent manner, dashed against the claimant, due to which he fell down and sustained multiple injuries, including fracture of left femur, fracture of right clavicle, middle 1/3, right temporal EDH, great abrasion over right wrist, and other injuries to his face and body. Claimant was shifted to Anugodu Government Hospital and then shifted to Kaveri Hospital, Mysore, where she took treatment as a inpatient, underwent surgery. The clavicle bone, screen grafting was done, and she has spent more than rupees 3 lakhs towards medical treatment. She stated that she was working as a coolie and earning rupees 15,000 per month. Hence, she filed claim petition seeking compensation. The respondent filed statement of objections, denied the claim of the claimant, including age, avocation, income, and the negligence that was attributed against the driver of the offending vehicle. On the contrary, pleaded that the negligence was due to the claimant herself. Stop. Tribunal framed issues to establish and substantiate the same. Claimant examined herself as PW1. Dot mark exhibit P1 to P21. Also examined the doctor as PW2. On the basis of evidence produced by both the parties and the submissions of learned counsel, tribunal awarded total compensation of 5,48,919 with interest at 6% to be paid by the insurance company. It's the vehement contention of learned counsel for the appellant that the tribunal is awarded meager compensation. Assess the disability to a lower extent. Income is taken at a lesser amount and has not awarded suitable compensation under other heads. On these grounds, he seeks to allow the appeal, consequently enhance the compensation. Per contra, learned counsel for the insurance company contends that the tribunal is awarded just and reasonable compensation. He sustains the order of the tribunal by contending that in view of there being no proof of income, notional income is taken at 7,080, which is correct and does not call for interference. So also the assessment made by the tribunal with regard to disability does not require interference, as the doctor has not opined specifically with regard to disability to the whole body under the circumstances. Left with no alternative, tribunal has assessed 1/3 disability, which is correct. Same does not call for interference. On these grounds, he seeks to dismiss the appeal. I have heard learned counsel for the appellant and counsel for the respondent insurance company. On perusal of the judgment and award, exhibits P1 to P21 are marked, out of which P1 to P8 are the police records, which depict the filing of FIR and laying of charge sheet against the driver of the offending vehicle. Exhibit P8 to P21 are the medical bills, disability certificate, and the prescriptions for the injuries sustained by the claimant. Negligence is rightly attributed as against the driver of the offending vehicle. Stop. Now coming to the question of age, avocation, income, and disability. It is seen that the claimant was aged 35 years as on date of occurrence of accident. The appropriate multiplier, the said case would be 16, which is correctly taken by the tribunal, same is not interfered. The tribunal has taken the disability to an extent of 12% in view of the Dr. PW2 not assessing disability to whole body. Full stop. Tribunal has assessed the income at 7,080 rupees based on the scheme of MNREG Act. Full stop. However, the notional income prescribed by the Legal Services Authority for the accident year 2018 is 12,500. Where there is no proof of income produced by the claimants, the tribunal and this court would have to relegate itself to the Legal Services Authority chart for assessment of income. Hence, 12,500 is taken as the income. With regard to the evidence adduced by the Dr. PW2, it is clearly stated that there is a disability to an extent of 12% to the right upper limb and 26% disability to left lower limb. In view of the fact that the appellant claimant is fully by profession, age 35 years, it would be difficult for her to work if there is a disability to an extent of 26% to the left lower limb, as she is involved in physical activities. But however, since the doctor has not assessed the disability to whole body, tribunal has taken the disability at 12% by dividing into 1/3. A marginal increase requires to be granted with regard to disability, considering the fact that the appellant claimant is a coolie and her entire physical activities involves much strain to the lower limb. Therefore, on a guesswork, 14% is taken as a disability. Full stop. We have to say, no, I will take 14. In view of the above, the loss of future earning capacity due to disability would be 12,500 into 12 into 16 into 3,36,000 as against 1,63,123. Towards pain and suffering, tribunal is awarded 50,000. Towards loss of amenities in life, another 50,000. And towards medical expenses and treatment, 2,66,636, which does not call for interference. No, I have increased on the disability. Pain and suffering, 50,000 for one fracture. Huh? 3 fractures. Pain and suffering, an additional amount of 25,000 is awarded, making it 75,000. Loss of amenities is granted at 50,000. An additional 25,000 is awarded under this head. Towards attendant charges, food, nourishment, and special diet, 5,000 is awarded, whereas claimant was inpatient for 9 days. An additional 10,000 is awarded under this head. Towards loss of income during later period, in view of this court enhancing the income to 12,500 per month for a period of 3 months would be required for a recuperation and to get back to normal day-to-day activities. 12,500 into 3. 37,500 is awarded.
Implants removal again 50,000 get the rate at 2 implants were removed.
Doctor Elidara.
ಹೌದು ಐವತ್ತು ಸಾವಿರ ಇದೆ.
ಎಲ್ಲಿ ಓದಿ?
Patient
read it.
Patient requires implant removal. The cost of the surgery will be around 50,000. As on today, exclude any emergency treatment that may require for the betterment of the patient.
Therefore, PW2 doctor has stated on oath that for future medical expenses for removal of implants, 50,000 would be required. Considering the same, an amount of 30,000 is awarded for future medical expenses. In view of the above discussions, claimant would be entitled to total compensation of
8,35,136.
8,35,120,
136.
130, na? 130,
136.
130. As against 5,48,919. Accordingly, I pass the following order. Appeal is allowed in court. Judgment is modified. Claimant is entitled to total compensation of so and so as against 548,919 at 6% interest. Full stop. Enhanced compensation shall carry interest at 6%, which shall be paid within 4 weeks from the date of receipt of copy of the order. Satisfied? Satisfied?
That's right.
The entire enhanced amount shall be released in favor of the claimant upon proper identification.
My lord, one submission, my lord.
Hmm.
Serial number 7, my lord, your lordship has heard the arguments on other side.
51. Yes, I will take up your matter. Please wait.
Please.
Yogesh. He wants time. Yavaga? Request release this matter on 23rd. 23rd. This date is 23rd. Which is the other one you want? Which is the other matter? 71. Same council. One. Last case only 70. 71 ಎಲ್ಲಿ ಹುಡುಕೋದು ಯಾವ್ದು ಹೇಳಿ ನೋಡಿ ಹೇಳಿ ಅಲ್ಲ all right next $52 ಬಂದಿಲ್ಲ ಅವರು ಹನುಮಂತಪ್ಪ ಬಸವಣ್ಣಪ್ಪ ಸೋಮಪುರ್ not here. Matter is called out for the second time. There is no representation on behalf of respondent. Senate counsel for the appellant is present. Release next week.
Number 53.
Is that batch matter?
7.
Told. Let them come. Vijay Kumar.
Please, my lord.
Serial number 7.
Yes, my lord. A marginal enhancement only with regard to the notional income, my lord. The rest of the thing is just unreasonable. And some amount, my lord, towards pain and suffering. Pain and suffering is awarded, my lord, 45,000. That is just unreasonable. But only loss of amenities, another 10,000 can be awarded. And only the notional income can be enhanced. Rest of the thing is just unreasonable.
And the argument in Mr. Girimalaya idralli disability jasti barutte. What was your argument? And this is the right lower limb.
21% to the right lower limb. Actually, 21% other 7% agate, but tribunal has taken 12%. That is on higher side.
What is the vocation? Driver, driving license for people. All right. Anyway, you have not brought it. We'll go with the same 12,500 into 12%.
Please, my lord.
Yaudu? You have not produced photograph. How to know what you are saying is correct? Doctor has not said anything about whole body disability.
Only particular limb, my lord. Actually, 7% should come. As another 5% is more.
7% ಆತರ
Since
ಮಾಡಕ್ ಬರಲ್ಲ. ನೀವು 7% whole 1/3 ಮಾಡಕ್ಕೆ ಎಲ್ಲದಕ್ಕೂ ಬರಕ್ಕಾಗಲ್ಲ. That's what Supreme Court has also said time and again. If he's a driver and materials are placed on record, if he's a tailor and if he's a carpenter, on the basis of injuries suffered which deforms and changes his entire life, the purpose of Motor Vehicles Act is to bring him back to the same position as he was earlier. It's not bad, at least to some extent. You have not produced any material. How to believe? You have not placed any material. Even now, you have not shown your driving license, which is that vehicle he was driving.
And under whom he is working?
ಏನು ಹೇಳಿಲ್ವಲ್ಲ ನೀವು?
ಏನಿಲ್ಲ.
According. This appeal is preferred by the claiming. Challenging the judgment and award of the 19th Additional Judge MACT Court of Small Causes Bengaluru in MVC 7662 of 18 dated 25 January 22 on the ground of inadequate and meager compensation. The claimant was proceeding on his Honda Duo motorcycle bearing registration number KA51HB2499 as a pillion rider on 30th 11/2018. At that time, the rider of the said vehicle was riding the vehicle in a rash and negligent manner. And when they reached near Venkatraman's house near Kottigehalli, Kagalahalli Road, at that time, due to the sudden crossing of the road by a dog, in order to avoid the said animal, the rider abruptly applied brake, due to which the vehicle turned turtle, skidded, and he fell down along with the pillion rider, who sustained injuries, grievous injuries. Claimant was shifted to Sanjay Gandhi Hospital, Bengaluru for treatment, where he was admitted as inpatient for more than 18 days and took medical treatment and expended financial expenditures. He was hale and healthy, aged about 26 years, working as a driver, earning rupees 20,000 per month. 25 or 26? ಮತ್ತೆ ನೀವೇ 26 ಅಂತ ಹೇಳ್ತೀರಲ್ಲ. Hence, he filed claim petition seeking compensation.
Even according to driving license, he is completed 25 years in almost 9 months in 26 years.
Almost 9 months ಅಂದ್ರೆ ಇನ್ನು 26 ಆಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, but 25 ವರ್ಗ up to 25 ಮಾತ್ರ ಇರೋದು. ಮಲಾಡ್, that is the mistake we are committing. ಹಿಂಗಿದ್ರೆ ಹಂಗ್ ತಗೊಳ್ತಾ ಇದೀವಿ, ಆ ತರ ಈ ತರ ತಗೊಳ್ತಾ ಇದೀವಿ. It is up to 25 years, up to 25 years. Up to 25 years.
Not up to.
Yes, my lord.
21 to 25.
To 25 years. 25 years, that's all.
So he will become
25 years over. After 25 years, he has completed 9 months.
He will become 26 after he finishes the 12 months.
Then, my lord, see, it is 26 is running, 25 is over. My lord, 1 rupee means 99, 100 paisa.
That is already decided in several cases.
My lord, that is the mistake committed, my lord, because they have not properly assisted by advocate.
So next time
They
you
have
can,
not made the distinction.
next time you can assist this court.
Yes, but I am assisting your lordship. My lord, 25 years means once he completed on a particular day, he is completed 25 years. Then he is running 26 years. That cannot be 100 rupees on up to 99 and 100 rupees. It is not up to 200 rupees, it's 100 rupees.
What the tribunal has done.
Tribunal yet has observed like that only. But he has taken only a 18 multiplier instead of 17 multiplier. Actually, they should have taken 17 multiplier.
You should have filed appeal.
Lack of assistance from the advocate, these the judgments are happening.
All right, why you did not file appeal? Now I will appreciate it.
In each and every case, I have to file appeal because there is a lot of lacuna. Lot of lacuna in each and every case.
Irad appeal haakake ನಾವು ಇರೋದ್ ಕೇಳಿ judgment ಬರೆಯಲ್ಲ.
ಇನ್ನು double ಆಗ್ಬಿಡುತ್ತೆ compensation, but we are generously satisfying the award and not filing appeal.
ಏನ್ ಬರ್ದ್ರಿ?
He was a hale and healthy, aged 26 years, working as a driver.
In fact, my lord, yesterday, my lord, your lordship has granted stay. Yesterday and also day before yesterday, because we have deposited full amount with interest.
Yes.
Because there is a contributory negligence and also the rate of interest. But only in few cases we can do it.
Okay.
Because there are 6 connected matters we have challenged. Though
He was hale and healthy, aged 26 years, working as a driver, earning of rupees 25,000.
their case is 26 years.
Okay. In contentions of the claimant.
He filed claim petition seeking compensation.
Respondent number 2 did not appear before the court, was placed ex parte. However, respondent number 1 finds statement of objections denying the claim of the claimant, including age, avocation, income, and the negligence attributed as against the rider of the motorcycle, and sought for dismissal of the claim petition.
Claim petition law 26 years. So appeal law 26 years.
And sought and to establish the same, claimant examined himself as PW1 and got marked exhibits P1 to P11. He examined the doctor as PW2 and got marked exhibits P12 and 13. He also examined an eyewitness by name Mahesha as PW3. Whereas the respondent number 1 examined its senior medical officer in lieu of chief as RW1 and got marked exhibit R1 to R2. For what purpose you examined that RW1 and what he has stated?
To prove that injury and also disability not to that extent what was stated by the claimant. Because the doctor Prakashappa, my lord, in each and every case he go on giving evidence by inflating and exaggerating injury and disability.
This is the first case I am seeing insurance company contradicting a doctor by adducing evidence.
No. I have made several submissions against Dr. Prakashappa. Your lordship will also come across in so many cases.
You should do that. You should go file a complaint before the medical council.
My lord, though complaint was given, my lord, nothing has happened in so many cases.
Bring it to the notice of the court. We will take action.
Even in some cases, action also taken.
Based on the evidence, oral and documentary, tribunal awarded total compensation of rupees 5,49,257 with interest at 6% per annum. Be paid by the insurance company. It's a vehement contention of the counsel for the appellant that the award of compensation is on the lower side. Tribunal has failed to take into consideration of proper income for assessment, so also the multiplier and the disability, and hence he seeks to allow the appeal, consequently enhance the compensation. Per contra, Learned Counsel for the insurance company contends that the tribunal is awarded just and reasonable compensation which does not call for interference. He also sustains the order of the tribunal and contends the disability assessed is on the higher side. So also the multiplier is on the higher side, which requires to be reduced. On perusal of the exhibits P1 to P13, the police records clearly indicate filing of FIR and charge sheet against the rider of the motorcycle. Hence, negligence is rightly attributed for causation of the accident and the injuries suffered by the claimant. Medical bills and documents of prescriptions are produced to show the injuries sustained and the expenditures met. Now, coming to the question of age, avocation, and income. Tribunal has taken the income at 11,000 per month, whereas the notional income by the Legal Services Authority chart for the year 2018 is 12,500. Same is taken in the present case. Claimant is age 26 years as stated by him in the claim petition. Tribunal has taken the age of 25, assessed the multiplier as 18, which is accepted and the same is not interfered. The doctor has assessed the disability to an extent of 21% to the right lower limb, however not expressed opinion to the whole body disability. Tribunal assesses the disability at 12%, which is accepted. The same is not interfered. In view of contra evidence placed by the insurance company by way of RW1, under the circumstances, the loss of future earning capacity due to the disability would be 12,500 into 12 into 18 into 12%, 3,24,000 as against 2,85,000. Full stop. Para. Towards pain and suffering, tribunal is awarded 45,000, which is retained. Towards loss of income during later period and rest period, tribunal is awarded 22,000. In view of this court enhancing the income to 12,500 per month and claimant having incurred disability to an extent of 21%, at least 3 months period would be required for recuperation. Hence, 37,500 is awarded under this head. Towards medical expenses, 1,57,137 is awarded, which is not interfered. Towards attendant charges, food, nourishment, and conveyance, the tribunal is awarded 10,000. Payment was inpatient for 18 days. An additional 20,000 is awarded under this head. Towards loss of amenities, the tribunal has awarded 15,000. An additional 25,000 is awarded under this head. Towards future medical expenses, tribunal is awarded 15,000. Doctor ಹೇಳಿದ್ದಾರೆ? The same is retained.
ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಇದುವರೆಗೇನು ಮಾಡಿಕೊಳ್ರಿ.
Same is retained.
Yes, madam.
In view of the above, claimant would be entitled to total compensation of
6,48,637.
6,48,637 as against 5,49,257 along with interest at 6% per annum. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. Claimant is entitled to so-and-so as against so-and-so. Enhanced compensation shall carry interest at 6%, which shall be paid within a period of 4 weeks from the date of receipt of copy of the order. All other entire enhanced compensation shall be released in favor of the claimant.
Achha, please.
Yes, 65. Because?
This is a partner matter.
Let's first up learn process for the appellant release next week.
A court officer. Court officer,
ನಿಮಿಷ ತಾಳಿ ಸರ್.
serial number 64.
ಇದೆ ಮಾತು. ಹತ್ತುವರೆ ಇದೆ ಅಲ್ಲ ಸರ್ ಇಲ್ಲ? ಹತ್ತುವರೆ ಇದೆ. ಹೇಳಿ ಸರ್.
Serial number
Madam?
64, madam.
64 ಇದೆ ಸರ್.
ಇದೆಯಾ?
Madam,
ಹೇಳಿ ಸರ್, ಹೇಳಿ ಸರ್.
serial number 39. 39.
List along with some MFA number given, sir.
Okay, madam. Thank you.
Court officer? Court officer?
Hey.
Serial number 64 adjournment ಬೇಕಿತ್ತು ಮೇಡಮ್.
64 ಅಡ್ಜನ್ ಆಗಿಲ್ಲ. ನಾನು ಕೊಡಕ್ ಬರಲ್ಲ ಮೇಡಮ್.
ಓಕೆ ಮೇಡಮ್ ಮೆನ್ಷನ್.
End of the list. End of the list.
Yes.
68.
68, 8 February. Pandurang Naik, at request of the councils, release this matter on 8th February.
On AS.
Heard the council for the appellant. Issue notice to the respondents. On IA and main. Pending consideration of IA number 1 of 24. IA number 2 is taken up to imposing certain conditions. There shall be stay of operation and execution of the judgment and award dated 15/4/22 in MBC 7351 of 22 passed by Court of 24th Additional Small Causes Judge MACT SCCH 26 at Bengaluru, subject to the condition that the appellant the second time remand ಆಗಿತ್ತ first time. You filed miscellaneous. That came to be dismissed. Why? Huh?
But we doesn't know notice happening.
All right. Depositing 50% of the award amount before this court within 4 weeks on the date of receipt of copy of the order. From today. Today. Huh? That amount shall be kept in a fixed deposit in a nationalized bank for a period of 6 months and thereafter continued unless otherwise modified. Yuvatidya.
Pastor matters. Serial number 53.
63.
53, sir. Gotcha.
You have already argued. No problem. You want to add anything?
So far as it has been lost. It has been covered by the
Though I am also bound by the Supreme Court, but we are quantifying the Peters ಬೆಲೆ 1 ಲಕ್ಷ ಇಟ್ಟಿದೆ. Human values have totally gone. I don't know how. If you go buy an animal pet, you may not probably get for that much amount also. 1 lakh rupees for fetus, 9 months pregnancy.
good decisions.
But what does the Hindu law say? Fetus is entitled or not entitled for a share in the joint family property.
That's entitled.
Yes. On conceiving itself, entitled. 9 months pregnancy. If not for that accident, you would have been a baby boy or a girl. living in the society. Why that lady is not come? Every day she is here. I passed it over because normally she comes every day. Heard learned counsel for the appellant, learned counsel for the corporation. So here the respondent claimants. The list. When do you want? 7th February. Yes. Idರಲ್ಲಿ. Ended in acquittal because of lack of evidence or hostile? No, it is not honorable. Honorable acquittal is different. This must be lack of evidence. There is a death, how can he be honorably acquitted? The definition of honorable acquittal is different. It is acquitted, not honorable acquittal. Honorable acquittal means totally different. Despite having all material placed, evidence adduced.
I am able to.
Yes, that honorable acquittal, that is given only for the reason. No, this terminology is given for the reason that when you are acquitted honorably, you will be entitled for future employment. That is the reason this word terminology is used. Otherwise, there is no need for the courts to lay down one more terminology of honorable acquittal. Acquittal is acquittal. But here must be lack of evidence or hostile. But there is no charge sheet as against the auto rickshaw. That's what canvassed by your colleague. He has argued well. Okay. Next.
Number 54. Vinay S.
And he was asked to read the relevant portion of the authorities which they are derived from his part of so last occasion it is submitted and today is kept for my reply on that. In fact, before commencing my complaint, I will submit my answer. Today, similar matter had come up with very much the same question which goes in these two appeals was came to be considered by this honorable court. And this honorable court avoids a conversion which already furnished and I ordered the matter and held that the claimants would be entitled only towards the loss of estate, which will be 25% of the income plus future prospects based on that appeal taken in this post order. And even have raised my hand for two judgments rendered by this honorable court in a similar case under similar facts and circumstances, in which the judicial bench has said it's only the loss of estate to the extent of 25%. And they committed to my complaint. Now, what's the already punished these judgments?
This is a case where the parents and in-laws for the death of husband and wife.
Yes. In case of husband, his parents have made a claim.
They will be entitled to loss of estate according to you.
That estate actually, as per the law laid down by this court, as far as then daughter is concerned, daughter-in-law and a daughter as far as parents number 3 and 4 is concerned, it is my own submission by us. Once claimant number 1 and 2 have already been held as a defendants in case of
they claim the dependency again here does not exist. Means they are excluded from making a claim. For a moment, let me consider, yes, lot of that taken care of the parents. Then it is for them to establish that they were depending on the income of the deceased. For that, they should have examined themselves while imposing.
They have not laid evidence.
They have not said anything. And the second aspect is that the request report which I, on the last occasion which I did out before this honorable court, would clearly depict that they were not staying with their daughter. And there is no recital as to that there was a financial dependency. And your lordship might rightly put up question to me, just because they were not staying together, whether that is suffice to hold that they were not dependent. And that question has been read by this honorable court in this judgment which now right now.
Read it.
It is a case, in the first case, my lord, at page number 2, it is a claim by husband and mother of the deceased. Paragraph number 3, my lord. I just
Husband
paragraph
and.
number 3, husband just to
Ah.
understand.
Hmm.
And the finding your lordship of find it in page 8, that is page 8, paragraph number 14.
Yes.
In Virendra's case, referred to Supra, the deceased was the mother of the claimants and she was the government employee. There is the claimants for agricultural duties. Therefore, in that case, it was said that they were dependent on the deceased. Therefore, the said judgment cannot be justifiably applied to the facts of the present case. The coordinate time of this court in Malavanda's hearing referred to Supra a detailed discussion held that in the case where the claimant was not depending on the income of the deceased, he is entitled to compensation only on the head of the loss of the state and not on the loss of dependency. In paragraph 20 is also post a judgment. In a similar circumstance, it was held that when both spouses are earning, the amount spent for personal and living expenses for each of them is comparatively higher. That is 3/4 of their income. Therefore, 25% of the income was computed as loss of the state. In BD Gopal's case, referred to Supra, by considering 50% of the income of the deceased as compensation on the head of loss of the state, no specific reasons were assigned. Therefore, that cannot be taken as a ratio on point. Hence, 25% of the income of the deceased has to be assessed as compensation under loss of estate. This is the finding by the Supreme Court. And the point which I just now addressed my notes that you are also to find in the next judgment. The next judgment in page 14, page 3.
Yes.
It is a interpretation by the major children in any compensation in respect of death of the mother, which your lordship will find at paragraph.
Mother.
Paragraph.
Yes.
And the finding regarding it is that page 23, paragraph number 18.
So the claimants were children.
Native children, they were claiming compensation towards the death of the mother.
Yes.
Paragraph number 18.
8, 1 8.
1 8. In page number 23, page 18.
Yes. Yes.
From the inquest report at exhibit P6, during the statement of petitioner number 2 was recorded, wherein he has asserted that appellant number 1 was residing in Bengaluru along with his wife. This statement is again corroborated by the statement of wife of appellant number 1, Sanna Almota. Hence, it is evident that appellant number 1 is residing in Bangalore independently. So, appellant number 2 said to have been residing with the deceased is not stepped into witness box, and there is no material evidence to show that the claimants were totally depending on the deceased. The deceased person was a coolie, and the petitioner appellants assert that they have no independent income. But in evidence, the claimants' status is shown as agricultural coolies. That itself discloses that they have independent income and they are not suffering from any disability. Under such circumstances, question of they being dependent on the deceased cannot be accepted. The tribunal has taken the income of the deceased at so and so. Thereafter, 25% of the same is taken as savings of the deceased, which culminate into estate on the said calculation. The tribunal is awarded a compensation of so and so under the head of loss of estate. But however, the income is taken at 8,000 per month appears to be on both sides. So 9,500 per month in respect of the accidents occurred in so and so day. equal to unskilled labor. Admittedly, in the accident case, the accident occurred in 2016, accident criminal here considering 8,000 instead of 9,500. The traveler has taken 25% of salary towards the savings. We can communicate into the state as well. This supported the decision of this court rendered in anything number so. And division bench of this court reported in INR so manual against the persecution duty. Undertaking the most by two major managers. Hence, disease could have saved 25% by spreading 25% towards the personal expenses and other family needs. Hence, it appears reasonable calculation to take 25% towards saving. The notional incomes also. So, why I read out this portion is the combined reading of these two paragraphs. What would emanate is that they should be in evidence to that effect that they were given. And once she is married, she herself is a police. She works in some form according to that, earning about 8,000 rupees as per the evidence. And they were not residing with the deceased at any point of time. Even keeping aside all these aspects, nothing prevented them to step into the witness box and say that even after our daughter getting married or being married to somebody else, she was supporting us financially. And the fact that they have a major son who's taking care of them, in the absence of any evidence, any material or record, whether the claimant would be entitled for loss of estate, loss of dependency or not, that is a point that arose for consideration before this court. Today, the MFA, an order being passed in an open court, court 128, a similar fact, where this honorable court considered 25%. Even I would, once the judgment is uploaded, I will furnish that copy as well.
Yes.
1076 bar 10,726 bar 2012. Where which similar view was taken by this honorable court that the claimant would be entitled for loss. Yes, yes.
Yes. That's all.
That's all.
Parents are considered as dependents. So citation for this member. I think that one that deduction has to be calculated and as per the yearly income is 8,000. Last date of I consider that he has submitted the salary certificate 8,000, but legal aid service it has to be calculated as 12,500. In another case, it is taken as a 15,000. And the London Council has submitted, there is no proof for the PW2 himself has entered into the parents as treated as dependents, and it has to be notional income has to be calculated on that citation has to be punished.
What about the parents of that lady? They have not stepped into the witness box.
The PW1 himself is the father-in-law of the deceased. In that case, he himself has deposed the unpaid father.
Our argument is that in the case of the death of the lady, her parents would be the dependents, is your argument, which she says that they have not stepped into the witness box to say so. Evidence ಮಾಡಿಲ್ಲ
Marriage 10 months ಆಗಿದೆ. 10 months ಆಗಿದೆ. Husband no issue. In that situation, husband and wife both 10 months. Definitely they are senior citizen parents. Definitely should have looked after the parents.
All right.
It is not the case that parents are residing in somewhere she is residing in India. They are residing within the 5 kilometers, 10 kilometers.
All right.
Their agricultural workers are doing poultry. Labor is the
But you have argued already.
Yes, ma'am.
What is this now? This is the same citation.
Same citation, I highlighted the relevant paras in that citation. Citation number 1, Jayashree judgment matter. Mother-in-law also treated as a dependent.
Okay.
Is held as mother-in-law.
Okay. That's all.
Yes.
Heard. Learned counsel for the claimant and the insurance company. List this matter on 16th. Let me just go through the.
Yes, yes.
Please.
If I need any. Yes, you can furnish. ತಗೊಳ್ಳಿ.
Number 55. It is Sidramaya.
Sorry. Other rates is
Huh?
for other rates is medical records. Purchase from Mali. On the connected case, sorry. So under other rates is.
So what the tribunal has done here?
The tribunal has awarded. 6521 and for medical expenses.
ಎರಡು ಕೇಸ್ ಇದೆ ಇದರಲ್ಲಿ. You are questioning where is that operative the tabular column?
Page number 20.
21 or not the previous one. So that is for the Uma Devi's case. Senior injury. So in Jairam's case, what is awarded? 6,521.
Medical expenses.
That's correct. 26,521 ಮಾಡಿದ್ದಾರೆ. Huh? Correct. So now
Medical expenses and incidental. Also not correct because of 48 days inpatient. Incidental expenses may be more than the.
no, you tell me what is the medical expense? 6,521.
That is what the tribunal felt that for.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿಲ್ವಾ ಇವಾಗ ನೀವು ಎಷ್ಟು ಬಂದಿದೆ?
Correct ಇದೆ ಇವರೆಲ್ಲ correct ಇದೆ.
No, medical expenditures are borne by the bills produced by the. ಅದು ಎಷ್ಟಿದೆ ಟೋಟಲ್? ಕರೆಕ್ಟ್ ಅಂದ್ರೆ ಎಷ್ಟಿದೆ? 6,521. Okay, that's what I'm telling. All right, 652, you are not in appeal. 6521 if we take for medical expenses. All right. But the compensation awarded is 20,000 towards pain and suffering. So only amenities and ಕೊಟ್ಟಿಲ್ಲ. So pain and suffering.
So one of the main bearing India. One of the main weight bearing board. 20,000.
What else?
Towards loss of communities.
Disability.
That has not been awarded for the management.
They're back in the same job, they're getting the same income.
Another that is with respect to loss of earnings. That may be correct. So I'm not claiming under loss of earnings. But amenities, nourishments. So even if you continue the very same job, it's suffering from some cost.
ಕೊಡೋಣ amenity ಕೊಡೋಣ.
Future loss of earnings are not claiming.
Correct.
And whether he is entered for 240 days in his career, he has 48 days he was inpatient.
ಅದಕ್ಕೂ ಕೊಟ್ಟಿಲ್ಲ. 48 days.
48 was inpatient.
50,000 can be awarded. Pain and suffering ಎಷ್ಟು ಕೊಡ್ಬೋದು ಮಿಸ್ಟರ್? How many fractures?
One fracture and two other injuries. One is main weight bearing bone.
Yes, what else? All right, what else? Loss of income laid up period? Rala. And you are not lost any income also?
For the management and conveyance charges.
Food, nourishment and conveyance.
And amenities. Even if you do the very same job, he's facing loss of compliance in his time.
Amenities. But the fact remains he has undergone a fracture.
Initial note of the facts.
Huh? See, if a person is admitted for 48 days, and how many days you were inpatient?
As per the medical fees they were proposed. So he only also. And I know that people he has come for next test. Not on the treatment that he has taken for the fees which he has produced, the speech people are all I believe the treatment. Inshallah, June. Looking to some of them
So Ayurvedic treatment is free.
only show that he's taking the treatment. They are not noticed any doctor so that he was admitted.
Conservative. ಹೋಗೋದು ಬರೋ ಚಾರ್ಜ್ ಯಾರು ಕೊಡ್ಬೇಕು? ಹೋಗೋದು ಬರೋ ಚಾರ್ಜ್ ಕೊಡ್ಬೇಕಲ್ಲ. So it will not be so huge, but it will be lesser. The Ayurvedic homeopathic treatment also is not free. Let it be. He has incurred some expenditure. So that will come down to a large extent. Food, nourishment and conveyance. How much can be about? How much? How much? Yes. That's all. That's all, Sidramaya.
Discomfort in his life.
Who has to say that? You alone. You can say, doctor has to substantiate that. No, but the discomfort, that is why amenities are given to you. That's what the appeal is preferred by the claimant. Challenging the judgment and award of the third additional senior civil judge of MACT Tumkur in MBC number 121 of 2019, dated 22nd March 2022. The claimant was riding a motorcycle along with a pillion rider. That is a Honda Activa two-wheeler bearing registration number KA06EY8693 near Town Hall Circle in front of THS building on 18/6/2018. To stop. During this time, a lorry bearing number KA06D1343, driven by its driver in a rash and negligent manner, came from their rear side and dashed against the vehicle of the claimant. Due to the impact of the accident, claimant and the pillion rider fell down and sustained injuries. The claimant was immediately shifted to MC Orthopedic Orthoscopy and Joint Replacement Center, Ashok Nagar, Tumakuru. He was admitted as an inpatient at MC Orthopedic Joint Replacement Center, where he took treatment for 2 days. After discharge, he took further treatment as an outpatient and incurred financial expenditure to the tune of 50,000 more and incurred physical disability. He stated that he was aged 55 years, working as a senior engineer in the railway department, earning salary of rupees 1,10,000. Due to the occurrence of the accident, injuries suffered, financial expenditures met, he filed claim petition seeking compensation. Respondents filed a statement of objections, denied the averments made by the claimant, including age, avocation, income, and the negligence attributed against the driver of the offending vehicle. Accordingly, sought for dismissal of the claim petition. Full stop. Tribunal named the relevant issues for consideration on the basis of the pleadings, and to substantiate the same, claimant examined himself as PW2. Witness PW2, and produced exhibits P17 to 28 and 31 and 32. So the doctor is not for this case. On the basis of the evidence adduced in both the cases, in this case, and after hearing the counsel for both the parties, tribunal awarded compensation of rupees 26,521, along with interest at 6%, and directed the insurance company to pay the compensation. Being aggrieved by the meager compensation awarded, claimant is before this court seeking enhancement. I've heard learned counsel for the appellant claimant and learned counsel for the respondent insurance company. On perusal of the exhibits, it is apparently clear that the accident occurred due to the negligence of the driver of the offending vehicle, which is depicted in exhibit P1 to P8, which are the police records. The medical records are produced to show the injuries sustained and the medical treatment expended by the claimant. In the present case, there is a disability has not been explained by adducing the evidence of the doctor, and no such certificate is also produced. Full stop. The point, short point for consideration in this case would be as to what is the extent of compensation that requires to be awarded under the head of pain and suffering, loss of amenities, medical expenses, as there is the question of loss of future earning capacity does not arise.
Here is for 62 days as per I can read the ticket.
Okay. 60
As per exhibit B,
inpatient.
no. Currently, here,
Ah.
not 48 days, it is for 62 days. As per exhibit B,
Leave salary details.
exhibit B1 is correct. That is very.
So this anyway you are going to get.
And then here, currently, we will get after retirement, up to 240 days and entered for encashment, lost pay leave.
So you mean to say for
I
this,
have lost 48 days, sorry, 62 days.
so for this 62 days you have not received it.
I'm not able to receive it unless I gain into my future or that has to be established. I don't know what will happen. Up to 240 days, I'm entered for a refund of the refund.
So what's the law on the point whether if you,
It's a well-set law. It's stated for years. Reimbursement of years by the accident law. It's a well-set.
huh? No, not the question of rest. Now, the fact remains that 62 days is a EL. That means he must have not have worked. You have not worked for 62 days. That is why he is shown as EL.
As he has to take this for 2 months or 1 month. Plus, suppose if he has taken a lot for some other reason, already is not entitled to check. Because there is no everything, and there is no discharge amount. Which hospital you cannot pay, not this. Discharge something we are present exhibit P. And exhibit P 24.
Records here.
It's for the doctor to say, whether he has to take 1 month or 2 months. Suppose if he has taken 6 months, may not arrest the.
Yeah, what does the discharge say?
It's not a discharge, it's a medication treatment certificate. And it's this.
So what stopped you from adducing the evidence of doctor or producing medical records to show?
Medical records produced.
No, that is for medical bills is different from medical records to show that you did not go to office and you were taking bed rest for 62 days due to the injuries. ಏನಾರ material place ಮಾಡಬೇಕು.
The short point for consideration in this case would be as to what is the extent of compensation or that which requires to be awarded on the heads of pain and suffering, loss of communities, medical expenses, and there is a question of loss of future earning capacity does not arise.
There is no question
No.
of loss of future earning capacity
Does not.
in view of there being no disability, as a doctor is not examined to express any disability to the whole body or any particular limb. It is also borne by the evidence and records placed that the claimant has continued to work in the same organization and there is no reduction in the salary. In the circumstances, this court will have to consider the medical expenses met, which is produced at exhibit P22 now. P22, which is 6,521, which requires to be awarded. Full stop. The tribunal is awarded towards pain and suffering 20,000. This court deems it appropriate to award an additional amount of 30,000 under this head, making it 50,000 in all towards pain and suffering. Towards loss of amenities, the 25,000 is awarded under this head. Towards food, nourishment, conveyance, and transportation, an additional 20,000 is awarded as the claimant has taken treatment through conservative method from Ayurvedic treatment. Let's take them up total. 6521 plus 50,000 plus 25 plus 20. 1,01,521. Claimant would be entitled total compensation of sums. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. Claimant is entitled to 1,01,521 as against 26,521, along with interest at 6% per annum. Enhanced compensation shall be paid within 4 weeks at 6% per annum. In the date of receipt of copy of the order. Entire compensation shall be released in favor of the claimant upon proper identification.
Ten. Pass over.
There's 6 cases. Yes.
Yes, sir. 2018. 20 days. Practice on the national culture of implementing law on this. Government, factor of the implementing law on the right side. The restoration of 0.5 millimeter on the high rate. The restoration of 1 centimeter over where the factor assessed of 15% disability. Disability. Even as not disability.
Now, what is the age and what is the avocation? What was he doing?
Data entry aspect. Also studying with the second semester.
BE second semester. Student. 20 years. ಯಾವಾಗ ವರ್ಕ್ ಮಾಡ್ತೀರಿ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ BE ಮಾಡ್ಕೊಂಡು ಅದನ್ನ ಓದಕ್ಕೆ ನಿಮ್ಗೆ ಟೈಮ್ ಸಿಕ್ಕಲ್ಲ ನೀವು ಡಾಟಾ ಎಂಟ್ರಿ ಹೆಂಗ್ ಮಾಡಿ ಪಾರ್ಟ್ ಟೈಮ್ BE ಎಷ್ಟು ಸಬ್ಜೆಕ್ಟ್ಸ್ ಇರುತ್ತೆ ಗೊತ್ತಾ ನಾಟ್ ಲೈಕ್ ಲಾ 5 ಸಬ್ಜೆಕ್ಟ್ಸ್ 18 ಸಬ್ಜೆಕ್ಟ್ಸ್ ಇರುತ್ತೆ 18 ಸಬ್ಜೆಕ್ಟ್ಸ್ ಓದ್ತಾ 1 ವರ್ಷನೇ ಕಡಿಮೆ ನಿಮ್ಗೆ all right anyway you will have to be given some notional income. What is taken according to him as data entry operator? Correct, that's a part time. All right, but the fact is he's an engineering student. BE second semester, RR college. What has the tribunal done? If disability is there. Doctor ಹೇಳಿದಾರ 57. Yes, read.
Is the place of completion of the sustained human disability sustained by the accident. Further, he relied on the in this case, the examination of the completion has a sustained the underlying subject. He has assessed the percentage at 78%. Ability of each antigen sensitivity of the
Whatever membership, 15%.
Yes. EW7 is doctor. What the tribunal is, nothing is taken. Tribunal is negative to that.
Yes.
Hmm.
Continuation of study in the future evaluation is not happening.
Huh?
Reasoning of the last continuation of study and future evaluation is not affected.
Where is the calculation made?
Internal page 26.
26. Uh, 2,24,000 is given. Pain suffering 50,000. Food nourishment 70. How many days inpatient?
But it will be
17. All right. Medical expense actual. Huh? Transportation 2,000. Amenities 50,000. Future medical expense 50,000. Yes. What else you want? ಏನಾಗಿದೆ ಅಲ್ಲೋಗಿದೆ ಅಷ್ಟೇ ಅದಕ್ಕೇನು ಡಿಸಬಿಲಿಟಿ ಊಟ ಮಾಡಕ್ ಡಿಸಬಿಲಿಟಿ ಇರುತ್ತೆ ಫಾರ್ ವಾಟ್ ಯು ಆರ್ ನಾಟ್ ಅ ಸಿಂಗರ್ ಆರ್ ಯು ಆರ್ ನಾಟ್ somebody who's doing anything with playing the flute or something or blowing trumpet in disability. At the max you would require maybe one more tooth replacement. That would cost amenities in life or another minor expenditures. Future medical expense, I was or any care. Surgery is required. Do you have any jaw dislocation? Have you produced any photographs to show? Huh? No. ಏನು ಕೊಡಲ್ಲ ಏನ್ರಿ ಮಾಡೋದು? Yes, madam, what is?
My submission. And in his cross examination, the certificate is continuing to the studies and he has completed his engineering. And there is why the tribunal has rightly not awarded any compensation that loss of future earning capacity is. It does not come in the way of carrying out this application and it doesn't come as part of the function itself. There seems to be some difficulty regarding sensitivity, but that will not come in the way he carrying out any job. And there is no dislocation of the jaw. It is a zygomatic arc bone fracture.
Whether there is any deformity, facial.
Situation of the arm was taken. Instead of 20, 25 that right. But usually injuries is extended personal accident. Secondly, there will be some inconvenience for the since in view of ability of heat and the sensitivity of the teeth, unable to achieve up to the stage from taking the type of either half foot or whole foot bench. This is the findings given by the tribunal. So, due to the disability, just for what is life management.
All right. Yes, anything else? Facial deformity ಆಗಿದೆನ್ರಿ for loss of marriage prospects. ನೀವು ಹೇಳ್ಬೇಕಂದ್ರೆ ನಾವು ನಿಮ್ಗೆ ಹೇಳ್ತೀವಿ.
ಇಲ್ಲ
ಅದೇ ನಾವ್ ಹೇಳ್ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ. ನಾವ್ ಹೇಳ್ಬೇಕಲ್ಲಮ್ಮ, ಅಲ್ಲಿ ಜಡ್ಜ್ ಆಗಿ ಕೂತ್ಕೊಂಡು ಏನಾರ ಹೇಳ್ಬೇಕಲ್ಲಮ್ಮ. ನೀವು ಮಾಡಿದ್ರೆ ವಿ ಹ್ಯಾವ್ ಟು ಪ್ರೊವೈಡ್ ಜಸ್ಟಿಸ್. You have to argue for your future deformity. If you are a student, how it is going to affect you. If you are a youngster not married, you have no marriage prospects, no girl is going to get married because of disfigurement. ಅದೇನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿಲ್ಲ, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಇಲ್ಲ. So that showing of hard food, even if that is taken into consideration, the marginal amount can be increased.
Because he's already afforded, because keeping that in mind, and it is some inconvenience, discomfort that is caused.
In later period. You were inpatient for 17 days. That is also just a statement made that you were working as a data operator.
And then the cross-examination, he says that there is no loss of academic year, is continuing to support. And at the time of accident, those who 6 semester leave had to be jailed, and he has completed his book.
That's all. But marginally will increase. This appeal is preferred by the claimant. Appeal challenging the judgment and award of the Chief Judge, Court of Small Causes, MACT Bengaluru, in MBC 3508 of 2018, dated 8 February 2022. The claimant was a pillion rider on a motorcycle bearing K06EY8493 when they were traveling on from AK Kaval to Hetanahalli on Tumpur Punikal Road on 13/2/2018. And they stopped by on the left side of the road to have a telephone conversation, during which time a car bearing K52M1055 came from their rear side and dashed against the motorcycle, leading to the occurrence of the accident and injuring the claimant, who was a pillion rider. Due to the occurrence of the accident, claimant had to meet financial expenditures and incurred financial loss also. Mentally, emotionally suffered pain and trauma. Hence, he filed claim petition seeking compensation against the respondents. Tribunal, the respondents appeared, filed a statement of objections. Denied the age, avocation, income, and the injuries sustained. So also the negligence attributed as against the driver of the offending vehicle, and sought for dismissal of the claim petition. Tribunal framed issues. Claimant adduced evidence. Examined himself as PW. What was he? PW4, and adduced the evidence of doctor at PW7 to establish the injuries suffered and the difficulties due to the occurrence of the accident. It is stated that the claimant was an engineering student at RR College. Along with it, he was doing part-time work as a data entry operator and earning rupees 8,000 per month. Learned Council contends that the compensation awarded by the tribunals on the lower side seeks enhancement of compensation, as the tribunal has failed to consider the disability encountered, the injuries sustained, the loss of future earning capacity. Hence, he seeks to allow the appeal and consequently enhance the compensation. Per controller counsel for the respondent insurance company. Contends that the tribunal is awarded just and reasonable compensation. Admittedly, there is no evidence with regard to disability or loss of future earning capacity, except to the fact that there is some injury in the sensitivity of the teeth and the mobility to the teeth. Other than this, claimant has not placed any cogent material to establish or show before this court that he has incurred such an injury that his future earning capacity is dented, and there is a loss of earning, loss of income, due to which this court should award suitable compensation under the head loss of future earning capacity. She further sustains the order of the tribunal, contending that under all other heads, reasonable compensation has been awarded. On these grounds, she seeks to dismiss the appeal. Full stop. The occurrence of the accident, involvement of vehicle, injuries sustained by the claimant due to the accident are all forthcoming by production of the police records and the medical records. Same need not be dwelled into further for establishing the same. Coming to the question of awarding compensation, tribunal has awarded towards pain and suffering 50,000. This court deems it appropriate to award an additional amount of 25,000 under this head. Towards food, nourishment, 17,000 is awarded, which is not disturbed as claimant was inpatient for 17 days. Towards medical expenses, on the basis of bills produced, 55,110 is awarded. It is also not disturbed. Towards transportation, 2,000 is awarded, same is undisturbed. Towards future medical expenses, 50,000 is awarded, same is also not disturbed. Towards loss of amenities in life, the tribunal is awarded 50,000. Considering the fact that the claimant is met with injuries to his teeth, which may be difficult for him to now chew hard food, or sensitivity with regard to the teeth, or in that case, maybe a replacement of a teeth or a surgery for permanent teeth or an artificial teeth. An additional amount of 25,000 is awarded and the loss of amenities. Under the circumstances, claimant would be entitled to total compensation of 2,74,110. Yes. Accordingly, across the following one. Appeal is allowed in part. Claimant is entitled to so along with interest of 6%. Enhanced compensation shall be paid within 4 weeks at 6% interest. Enhanced amount shall be released in favor of the claimant upon proper identification.
number 20, the Brushpendraya.
I am for the claimants, my lord, respondent claimants.
Harini Shivanand's name can be deleted. Registry to delete the name of Senate Counsel Harini Shivanand from the cost list. In view of Wakalat being filed by Senate Counsel Srimati Geeta R for R1.
20.
50.
20, sir.
I am for the respondent claimant, and I have also, my appeal is there, my lord, for enhancement of compensation.
Argument start madilla.
So, my lord, in this case, the accident has taken place on 6/12/2016, my lord.
Ibru idaralla appellant madli avare madli. Heli Mr. Suresh.
Yes, my lord. Yes. On 6/12/2016, while the auto rickshaw was taking reverse, then Your Honor dashed against the deceased, who was a pedestrian on road, my lord. As a result, he had sustained the grievous injuries, that is fracture of the right femur and fracture of the right radius. And immediately after the accident, he was admitted to the private nursing home, Dhanwant Clinic, Magadi Road. Thereafter, he was shifted to the Victoria Hospital, my lord, on the same time. So, my lord, here he has taken a treatment as an open reduction and internal fixation. And, my lord,
He sustained injuries after last of 1.5 years he died.
So is it disputed that the death has occurred due to the
Accident itself is
disputing?
every year. And here he himself has to be all the documents for the court.
and there was an operation for the internal fixation and open reduction. So here in this case, he has died on 29/3/2018 after 1 year, 3 months after the accident, my lord.
29/3/2018.
Yes, 29/3/2018. The accident has taken place on 6/12/2016. This is 1 year, 3 months after the accident, my lord. So, as per the evidence of the doctor PW3, my lord, there was a septicemia. For that septicemia, he has treated the deceased, my lord. He has treated the deceased and he has issued the medical certificate also. Death is due to the septicemia for the arising out of the accidental injuries, my lord. Exhibit P7 is the certificate issued by the doctor. And I have examined him as a PW3, my lord. And PW3, and there is a finding of the Honorable Tribunal at page number 13, para 17, my lord. Finding of the tribunal.
Yes.
To prove that the petitioner died due to accidental injury, petitioners produced medical documents. Exhibit P19 is inpatient case of Victoria Hospital. Perusal of Exhibit P19 reveals that father of the petitioner took treatment at Victoria Hospital from 6/12/2016 to 3/1/2017. Admittedly, petitioner not produced PM report, but examined PW3 Dr. Dhanwant Kumar, Dr. Vishal, Polyclinic, Magadi Road, Bengaluru, who deposed that accident took place on 6/12/2016 and after the accident, Noor Pasha took treatment in their hospital. During the cross-examination, it is denied suggestion that there is no nexus between the injury and death. PW3 deposed that Noor Pasha sustained that repeated infection which caused septicemia. PW3 further deposed that after discharge from Victoria Hospital, Noor Pasha came to his hospital for 7 to 8 times. deceased suffering from fracture pain. Hence, he oftenly came to hospital. Hence, by perusal of evidence of PW3 reveals that after the accident, Noor Pasha took treatment at Victoria Hospital from 6/12/2016 to 3/1/2017 and taking further treatment in the hospital of PW3. Hence, it shows that Noor Pasha died due to accidental injuries. Petitioners prove that their father, Noor Pasha, sustained injury in the above said accident and died due to accidental injuries. Hence, petitioners entitled for compensation. Accordingly to the petitioners, they are the legal heirs and dependents of the deceased. PW1 deposited that at the time of accident, her father was aged about 70 years and was hale and healthy, and he was earning rupees 15,000 per month by working blacksmith, and he was contributing all his earnings to the maintenance of their family. Due to the sudden and unnatural death of him, they lost their future dependency, love, affection, company of her deceased father and livelihood. Now they are facing severe financial problems. Hence, their lives have become dark and miserable. To show that they are the legal heirs of the deceased, Noor Pasha, petitioners have produced Aadhaar cards of Exhibit P8 to 13 and ration card at Exhibit P14, which shows that they are the legal heirs of the deceased, my lord. Here, my lord, my humble submission that accident has taken place in the year 2016, my lord. The notional income has to be taken 9,500. But here, the Honorable Tribunal has taken notional income 8,000 rupees, my lord. It is at para number 20 of the decision. 8,000 has taken the notional income and assessed the compensation loss of dependency, my lord. My humble submission, the 9,500 notional income may be taken and the compensation may kindly be awarded along with another head, that is the pain and suffering suffered by the deceased and the legal representatives. Because 1 year, 3 months he was impatient. Therefore, for that, the pain and suffering is entitled, my lord. He knew of the recent decision of the Supreme Court and also the our own High Court, my lord. Our own High Court decision, I'm sorry, I have not produced the decision before the court, but I can give the citations now, my lord. Here, 2014 ACJ 1671 Karnataka, Division Bench decision, and the Supreme Court decision 2023 ACJ 864, my lord.
Now
These two decisions, the Honorable
want the court to go and search for those judgments?
No, my lord, just because I was not knowing that today it was for final hearing. Therefore, I have not produced it for the court, my lord. So that's all. That's all, my lord.
Colleague, colleague. Your Latu's colleague?
Either house, sir. But these are the decisions. It was kept in the file, my lord. ಅದು ಅದರೊಳಗಿದೆ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಡಬೇಕಾಗ್ತದೆ. ಅವ್ರು ಬಹಳ ದಿವಸ ಪೇನ್ ಸಫರ್ ಮಾಡಿದ್ರ ಅಂತ ಅದೇ.
ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ಬೇಕಲ್ರಿ?
I will read it, my lord. Read it, my lord. 2014 ACJ 1671. It is at para number 10 of the judgment, my lord. Undoubtedly, the deceased having sustained grievous bodily injuries as an inpatient in a Markandeya hospital from 14/5/2010 to 21/5/2010, eventually succumbed to injuries. Keeping in mind the observations of the Supreme Court in N. Shivamal versus Managing Director, Pandian Roadways Corporation, 1985, 75 Supreme Court, wherein 5,000 was awarded towards pain and suffering who lived for 19 days after the accident under the shadow of death in an accident that occurred during the year 1978 and applying the very same to the facts of this case, we think it appropriate to award 25,000 towards pain and suffering since deceased was under shadow of death. In the result, this appeal is allowed in part. The judgment and award is modified, entitling the claimant to the following compensation, my lord. It is another decision, recent decision of Supreme Court, my lord. 2023 ACJ 864. I'll read it, my lord. The question of, my lord, the second para of the judgment of the Supreme Court, the question of law sought to be raised on behalf of the petitioner does not arise for consideration for the reason that the deceased son, the respondent, met with accident on 2010-2015 and remained hospitalized at Kolkata where multiple surgeries were performed to him. However, he could not survive and succumbed to injuries on 13/9/2016. In the peculiar facts and circumstances of this case, where the parents witnessed the pain, agony, and suffering of their son for almost 1 year, the compensation awarded by the High Court under the head of pain and suffering cannot be said to be without any basis. The parents themselves also suffered unbearable pain every moment during this entire period. So, my lord, this the pain and suffering, another one had compensation may kindly be allowed. That's all.
Yes. Involvement of pain. Most important components by the law. The accident that happened at the T6/2016 law. Very important. 51 R1.
Yavaga?
6/2016 law. Complaint was given on 13/2016. The last of statement. It says that on 6/2016 at 5 p.m. ಹಿರಿಯಾದಾರ ತಂದೆ ನೂರ್ ಪಾಷಾ ಬಿನ್ ಜಾನ್ 20 ವರ್ಷ ಕೆಲಸ ಮುಗಿಸಿಕೊಂಡು ಮನೆಗೆ ಹೋಗ್ತಿದ್ದಾಗ ಮಾಗಿ ರಸ್ತೆ 22 ಎರಡನೇ ರಸ್ತೆಯಲ್ಲಿ ದಾಟಲು ಹತ್ತಿನಲ್ಲಿ ತಿರುಗಿಕೊಂಡ್ರಾಗ ಇದೇ ಸಮಯದಲ್ಲಿ ಆಟೋ ರಿಕ್ಷಾ ನಂಬರ್ K0T865 ಚಾಲಕ ಹಿಂದುಗಡೆಯಿಂದ ನೋಡದೆ ರಿವರ್ಸ್ ಗೇರ್ ನಲ್ಲಿ ಇನ್ನಷ್ಟು ದಿಬ್ಬಕ್ಕೆ ಚಲಾಯಿಸಿದ ಡಿಕ್ಕಿ ಹೊಡೆದ ಪರಿಣಾಮವಾಗಿ ಪಾದಚಾರಿ ಕೆಳಗೆ ಬಿದ್ದಾಗ ಬಲಪಂಥಕ್ಕೆ ಬಿಟ್ಟು ಬಿದ್ದು ಅದೇ ಆಟೋ ರಿಕ್ಷಾ ಚಾಲಕ ಸಾರ್ವಜನಿಕ ಸಹಾಯದಿಂದ ಹತ್ತಿರದಲ್ಲಿ ದನ್ ಪಾನ್ ಕ್ಲಿನಿಕ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋದಾಗ ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ವಿಕ್ಟೋರಿಯಾ ಕರೆದುಕೊಂಡು ಹೋಗುವಂತೆ ತಿಳಿಸಿದಾಗ ಆಟೋ ರಿಕ್ಷಾ ಚಾಲಕ ನೂರ್ ಪಾಷಾ ಮನೆಗೆ ಇದ್ದು ಈ ಬಗ್ಗೆ ಪಿಡಿಯಾದಾರ ವಿಜಯ ತಿಳ್ಕೊಂಡ ತಕ್ಷಣ ತಗೊಂಡಿದ್ದಾರೆ. After the last offer, days.
24 days.
30.
30.
Last of 34 days. Delay giving only.
Delay.
When you have taken to the hospital, not their own test. It is the document they have produced by themselves. They have put on my He said that he has been examined by the church.
Who's examined?
Yes, sir.
Yaru?
The claimant has been examined. They themselves examined. As examination. Very clear. ನಾನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಮೊದಲು OP ನಂತರ IP ಮಾಡುತ್ತಿರುವುದು ಸರಿ. First, any person immediately after that they go OP and they taken as an inpatient. OP card self call ಎಂದು ಬಂದಿದೆ. It is their own document. It is self call. It is their own document, not our document. The evidence and documents produced by the claimant has to be appreciated as one. Please be my lord. In that context, evidence appeared to contradict to their own question of that state.
They say that that Odisha has drastic.
Huh?
That Odisha has been drastic.
MLC ಆಗಿದೆಯಾ?
No MLC, they are not producing that.
No MLC.
This is the document. This is the document produced by themselves.
Which is that exhibit?
Exhibit P. P to Mela.
Records ಇದೆಯಲ್ಲ.
Very clear.
P2.
P2.
Yes, madam. Exhibit 2, evidence of to Mela.
Which exhibit you want to read?
Exhibit P18 and P19 Mela. Patient case sheet.
P18.
P18 is authorization letter. P19 is inpatient case sheet Mela.
P18 is
Is an authorization letter, my lord, P18. And exhibit P19 is the case sheet of the Victoria Hospital.
Record self call ಇದೆ. Case of self call.
ಎಲ್ಲಿದೆ ಸೆಲ್ಫ್ ಕಾಲ್?
That examination Mela.
ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಸೆಲ್ಫ್ ಕಾಲ್ ಅಂತ? No, this is production of the medical records, alva. P18.
Yes.
The inpatient case sheet.
P18 is the production of records from Victoria Hospital.
Yes, ma'am.
Which is the document that shows it is a self-fall? History of self-fall. Okay. Yes.
On next page itself, the RTA has been written well.
Self-fall.
Yes, ma'am.
Near Magadi Road. Huh?
Accident happened on 3rd of 6/12.
Ah.
They have been complained on 30th for Mela. It is not a delay.
Ah.
And the owner of the action share not approved for.
Yes.
Also, the Dharmagiri clinic, they created a document to the client, compensation from the insurance company. And the decision of whether for these injuries, they are not putting any performance of Mela.
Now, where is the death certificate?
The death certificate is also Mela. No evidence has been examined.
The death certificate is the regular death certificate.
Yes, yes, Mela.
So that is not
Yes.
showing cause of death.
Mela. Mela. Right.
What about the medical records from the Victoria Hospital medical records ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ
And exhibit P5 also kindly.
there is a statement alleged history of road traffic accident 5 p.m. 6/12/16 Magadi Road patient was crossing the road hit by an auto. Date in what is the date of this?
Same day, same day, man.
They are not examined. This is completely not developed. They are
Yes. Which para?
On ridiculous.
ಯಾವುದು?
21 to
AKR 350. ಎಲ್ಲ ಕಡೆ ಸ್ಟೇಪಲ್ ಮಾಡಿದ್ರೆ ಎಂಟ್ರಿ ಓಪನ್ ಮಾಡೋದು.
Meticulous examination of the whole documentation. You have the view that elements of the Kutumba and include are actors as a consequence of result of physical injuries sustained by her in motor accident. As per the case of the claimant, the accident occurred on 9/5/2011 and in the said accident it is specific contention of the claimant that she suffered injuries to the left clavicle where death was occurred on 14/5/2011. There is a gap of almost 3 months. In the intervention period, the health status of the victim is neither narrated in the claim petition nor the same is brought on the record during the trial. The tribunal has related as Exhibit P9, which is the postmortem report, and has proceeded to dismiss the claim petition. The postmortem report clearly indicates that the death is on account of the myocardial infraction.
Myocardial
infraction. Questioning with regard to whether the evidence on record was good enough to come to the conclusion that death was occurred on account of physical injuries sustained in the road accident has been dealt with by the tribunal. The tribunal has adverted to the medical evidence on record, more particularly Exhibit P9, the postmortem report, and has come to the conclusion that death of Kutumba is not on account of physical injuries. The tribunal has taken into consideration all these crucial aspects of the case which have bearing on the question as to whether death is on account of the physical injuries. The tribunal has adverted that correct legal presumption by relying on the postmortem report. The grievances of claimant before this court that application was filed to secure the officials of the hospitals and send application has been readily rejected to be of no consequences. The postmortem report thinks the issue of any amount of evidence to be of no consequence in the present case and hand. We have carefully adverted to all the significant details elaborated by the tribunal in its judgment. We do not find any strong reason to replace the findings recorded by the tribunal and conclusion arrived at. The appellants have not been able to display the careful analysis of evidence by the tribunal and also the findings which have been arrived at. Careful analysis of judgment and award the tribunal and also details and record when it is grievances with a variance with the of the tribunal rightly come to the conclusion that the appellant claimants failed to establish the nexus between the injuries caused in the road accident dated 9/5/2011 consequently death. The rate of the decision made above 5 formulated base code answered in the affirmative according to appeal is divided rights dismissed. One more picture in Melod. 23 ACJ 1958 Melod. Division major against solutions. Totally and others Melod. Claim application 9/10/80. Access between the injuries and death. Injured
how to open the page? You give like that, you give it staple tagda. Hmm.
23 ACJ 1958 Melod.
Claim application, wind delivery of excess between injuries and death. Injured file a claim application for the injuries suffered in the accident. Died after 2.5 years. With the pendency of the claim application. Legal representation of the injured is converted the claim application for the claiming compensation for the death. And tribunal wording that the death was the result of accident injuries. Awarded compensation. Full certificate reveals that the injured suffered multiple injuries. The question mark of the next word. Head injury, indicating that there was only possibility of head injury, but discharge shows that there was improvement in his condition and no reference was made to the what head injury. Evidence that the injured disease led to the dilated cardiomyopathy, which is unrelated to the injuries suffered by him in accident. Whether there was no excess with accidental and death injuries and death, criminal award second technique.
Yes.
After talking about Dora by Malak. Here with respect to the medical documents. The hospital authorities have produced witness have been given for saying that
Yellow. Where are you reading?
The fact of evidence of the doctor, the exhibit R1 does not appear to have been printed by UCD. High Court, which did not place reliance of the document with the grounds on the ground that the brother of the injured stated that he did not know what was written in the document. The signature was taken on unpaid. The conclusion goes with the fact that the doctor will not take signature on a piece of paper, mentioning something which is not fact. Here in this case, my lord, evidence of the documents produced by themselves, the fact of delay in the complaint, and IMA has not been, they are not proved by IMA court. Definitely the vehicle is involved. Police have investigated the matter and seized the vehicle. Second.
So which is the vehicle involved here? So that FIR and charge sheet is filed.
Yes, charge sheet is filed.
There are so many decisions for any court. Even if the plea is also allowed, because this court has got past powers to appreciate the evidence, pretty by themselves allowed. And here in the case.
So is it your case that the auto rickshaw driver or the owner has colluded with the claimant? You have pleaded that way? You have led evidence?
No evidence.
Our death certificate could really won't set.
Any evidence, but the document itself speaks everything.
Where is the wound certificate?
Yes, it is there, madam.
Which is the exhibit?
Not produced. Substantiate the death due to the injuries. These decisions are recovered. Not examined any doctors of the hospital
that the injury sustained by
My lord, exhibit P5 may kindly be perused. Intimation to the police, my lord, by the doctor from the Dhanvantari clinic, who first time admitted to the hospital, my lord. Doctor himself has informed the police on the same day.
Yes, which is the document to show the wound certificate? And where is your death certificate, Mr. Suresh?
Yes, ma'am.
Death
Death certificate is exhibit P6 is the discharge summary of the Victoria Hospital, and medical certificate issued by the doctor exhibit P7. And
exhibit?
exhibit P7 is the medical certificate issued by the doctor, or private doctor, who has examined the petitioner, treated the petitioner at the ultimate stage.
Exhibit P7, huh?
Exhibit P7, my lord. And exhibit P6 is the discharge summary of the Victoria Hospital. Exhibit P17 is the death certificate, my lord.
Doctor examine ಮಾಡಿದಾರಾ?
Yes. 3, my lord.
Who's examined? Let us read this evidence. What's the name of the doctor?
Dhanvantari, my lord.
Dhanvant Kumara.
Dhanvant Kumar, yes, my lord.
PW3.
Yes, my lord.
PW3 is the doctor. Read.
Yes, it may not. But the very important may not, in the case of principal fall, like the vehicle has not been involved. The really vehicle has involved. They would have stated before the EPR student that the order which has been involved. There is delay of 24 days in giving the company. But point may not. Secondly, yes, the thing only fracture. He did out of here. Not due to the injuries.
A wound certificate, illegal.
I am not predicting law.
You are not produced wound certificate?
Here says that as examination. Now medical certificate no I have the class examination made by no the doctor by the exam for with the dependency of these people come on record claiming compensation. The AME report has not been produced. Police have not seen the vehicle.
The medical records from the Victoria Hospital is produced.
Yes, exit P19, inpatient record.
That goes against you. That shows self-fall.
The most important argument. Their own document.
Yes.
Now the division based judgment is very clear, my lord. And by my court, Mr. N. Kumar and Avi Rahim. This court permits I pass this judgment.
Kodi.
Very clear. Claiming compensation.
Is the Victoria Hospital the records are P18 or P19?
18, 19, both.
Make a list of decisions and produce it. How many judgments are there? Supreme Court and High Court. How the acts are creating the things.
Yes. Before I will dictate the judgment now. Yes, which is the paragraph?
Obstinate claim or not. Dismissal of claim petition. Appeal against. Fraud and fraud and justice never dealt with that. An attempt on the part of the first respondent owner to lead with the claimant in the fund of hoping saving the insurance company to pay the compensation. First respondent owner of vehicle admitted the accident and no objection to award the compensation. Even though the owner of the vehicle unmistakably terms has admitted the accident, The petitioner has no value in the eye of law. He has admitted something about which he has no knowledge and which he has not seen. It's clear that the admission is made the sole object of any compensation to the claimant, as it is the insurance company to pay, not the owner. So admission is the best piece of evidence. It cannot be accepted as a gospel truth. The court can insist on proof of false fact if the admission is not satisfactory. In the instant case, since the court has not satisfied, it wanted the claimant to prove their case independently. Claimants have visibly failed to prove their case. On facts held, the accident took place on 26/6/2001. The injured died on 28/6/2001. No complaint is lodged by the father of the injured, stating as about the case now pleaded. According to him, he went to lodge a complaint on 28/8/2001. They refused to receive it. Therefore, he lodged a private complaint before the judicial magistrate on 31/8/2001. As earlier expired charges are also professed both by the police and the claimant. The vehicle involved in the accident was never seen by the police. It is verified, my lord. The truth comes during investigation by the insurer. Under these circumstances, the tribunal justified its decision.
ಏನು ಎರಡೇ ದಿನಕ್ಕೆ 2 days only here. In this case, only 2 days.
No, yes, 24 days delay in complaint, my lord.
No, in this case, there's a 2 days delay. Accident happened in 26th June. He died on 28th June.
Here, lord, one of the year.
Year is changed. 1 year.
So what is the basis of the tribunal allowing the claim petition?
The only thing is the conclusion.
My lord, I have produced 3 MFA decisions also of our own High Court. At the trial court, my lord. At the trial court, I have produced it. Same with regard to the nexus of injuries.
Where is the nexus of injury? You died of what?
Septicemia. Septicemia is because of the injuries sustained in the accident, my lord.
The injury ellagitte nimge.
PW3 has stated before the court, my lord. PW3 is a doctor.
Where you sustained the injury? Which part of the body?
Yes, my lord. He has sustained the fracture injuries, my lord. Open reduction and internal fixation has been done. Your lordship may kindly see the discharge summary of the hospital and as well as in the discharge summary of the hospital, my lord, the treatment given, my lord, here, hemi replacement orthoplasty with diplower prosthesis, CR/ORIF with K-wire plastering for a distal, even in the case sheet also, Victoria Hospital case sheet also, it can be seen, my lord. Exhibit P19.
Even in the document, number 3 clinic. Accident in by auto.
Left leg femur fracture, exhibit P7, the evidence of doctor certificate.
Photograph of the body. body and anatomy.
ಇಲ್ಲ ಇದೆ.
Right distal radius L/3, Mr. Vishwendra. Huh?
Hands. Right hand, my lord.
Right distal radius.
He was inpatient accessible to those 50, 31 to those 70, discharged.
So there was a fracture of the right distal radius?
Yes, my lord. Right hand and left leg.
Right hand and femur.
Left femur.
Not only exhibit P6.
You have died after 1.5 years.
1 year, 3 months, my lord. Yes, my lord.
In 2018. One year, 3 months.
Yes, yes.
Where is the nexus and relationship to the accident and the death?
He was under treatment. As an outpatient, he was taking treatment with PW3. PW3, who is treated doctor, he has given the evidence before the court, my lord.
But you have suffered injury of the fracture of distal radius and femur.
Yes, my lord. Femur, even that is open reduction and internal fixation has done, my lord. Femur. And here, there was a wound, my lord. He was under treatment. In his evidence, he has stated repeatedly he came to the clinic, my lord, and he has taken a treatment for septicemia, for infection of that injuries.
All right. What is septicemia?
Yes, my lord. It is an septicemia.
Take a printout, that will be faster, I think. Septicemia.
Blood poisoning by bacteria.
You know?
Blood poisoning by bacteria.
By bacteria. No, now what you are relying, Mr. Suresh, is only on the basis of your doctor private clinic.
Yes,
where is the evidence and what is the document he has given you?
my lord. Yes, 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 my lord He has given exhibit P7 and P5, exhibit P5, exhibit P7 and evidence PW3. Exhibit P7, the opinion has given for the cause of death.
Have you cross-examined this doctor?
Yes, cross-examined.
It is evidence.
I will read, man.
No, not you, sir. Let him read.
Yes.
It's examined as what?
ಮಾಡಿದ್ದೇನೆ ನಾನು MBBS ಓದಿದ್ರೆ 1972 ಸರ್ವಿಸ್ ಮಾಡಿ ಪ್ರೈವೇಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ದೇನೆ. ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದ್ರಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಮಾಡಿರ್ತೇನೆ. ಡಿಪ್ಲೊಮಾ ಮಾಡಿ ನಾನು ಡಿಪ್ಲೊಮಾ ಮಾಡಿರ್ತೇನೆ. ನನ್ನ ಕೇಂದ್ರದಲ್ಲಿ ಅಮೌಂಟ್ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದೇ ಪೇಷಂಟ್ ಸೀರಿಯಸ್ ಇದ್ದಾಗ ಮಾತ್ರ ಎಂಟ್ರಿ ಮಾಡುತ್ತೇವೆ. 5 ವರ್ಷಗಳಿಂದ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನೆ. ಆದರೆ ಕಡಿಮೆ ಕೇಸ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನೆ. 2013ರಲ್ಲಿ ಇಲ್ಲಿಗೆ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ. ನಮ್ಮ ಕ್ಲಿನಿಕ್ 4 ಬಿಟ್ಬಿಡಿಬೇಕು. ನನ್ನ 4 ಜನ ಸ್ಟಾಫ್ ಇದ್ದಾರೆ. ಕ್ಯಾಶ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತೇನೆ. ಇದೇ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಕಳೆದ ನಡೆಸುತ್ತೇನೆ. ಅಡಿಗೆ ನ್ಯಾಯಕ್ಕೆ ಆಗಿರೋ ತೊಂದರೆ ಇಲ್ಲ. ನ್ಯೂ ಕ್ವಾರ್ಟರ್ನಲ್ಲಿ 30 ಅವರು ಕಾರ್ಡಿಯಾಕ್ ಪೇಷಂಟ್ ಆಗಿದ್ದಾರೆ. ನಾನು ಜನರಲ್ ಫಿಸಿಷಿಯನ್. ನಾನು ಕಾರ್ಡಿಯಾಕ್ ಮಾಡಿಲ್ಲ. ನ್ಯೂ ಕ್ವಾರ್ಟರ್ ನನಗೆ ಸುಮಾರು ಸಲ ಬಂದಿದ್ದಾರೆ. ಮಕ್ಕಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ನಾನು ರಿಕವರಿ ಆಸ್ಪತ್ರೆಗೆ ಕಳಿಸಿದ್ದೆ. ಅವರ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ. ಅವರಿಗೆ ಸುಮಾರು 20 ವರ್ಷ ಇರ್ತಾರೆ. ನಂತರ ನಾನು ಕ್ಲಿನಿಕ್ ಬಂದಿದ್ದರು. ಅವರು ನಂತರ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಮಾಡಿಸಿದಂತೆ ಹೇಳಿಲ್ಲ. ರಿಕವರಿ ಆಸ್ಪತ್ರೆಗೆ ಡಿಸ್ಚಾರ್ಜ್ ಆದ ನಂತರ ನಾನು ಕ್ಲಿನಿಕ್ ಬಂದಿದ್ದರು. 3 ವರ್ಷ ವಯಸ್ಸಾದ ಕಾರಣ ಅವರು ಮೃತಪಟ್ಟಿದ್ದರು. ಕಾರಣ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಮಾಡಿ ಹೇಳಿಲ್ಲ. ಸಾಕ್ಷಿ ಅವರ ತಾಯಿ ನಾವು ಕಾರಣ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಮಾಡಿಲ್ಲ. ನ್ಯಾಚುರಲ್ ಡೆತ್ ಇಲ್ಲ. because of that he has not been accepted. ನಿಶಾನ 7 ಸರಿ ಉಪಕಾರದ ಗಾಯಗಳು ನಾನು ಅಂತ ಸರಿಯಲ್ಲ. ಅಕ್ಷಿತ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿ ಸಿಮಿ ಆಗಿತ್ತು ಎಂದು ತಿಳಿತಾರೆ. ಡಿಸ್ಚಾರ್ಜ್ ನಂತರ ನಮಗೆ ಕಂಟಿನ್ಯೂ ಟ್ರೀಟ್ಮೆಂಟ್ ತೆಗೆದುಕೊಂಡಿಲ್ಲ. ಕಂಟಿನ್ಯೂ ಟ್ರೀಟ್ಮೆಂಟ್ ತೆಗೆದುಕೊಂಡಿಲ್ಲ ಅಂತ ಸರಿ. ಈ ಕೇಸಿನ ಬಗ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ದರೆ ಸಾಕ್ಷಿ ಕೊಡ್ತೀನಿ ಸರಿಯಲ್ಲ. ನಾನು ಬಂದುಕೊಂಡ ತೆಗೆದುಕೊಂಡು ಬರ್ತಿದ್ದರು. ಚೆಕ್ ಮಾಡಿ ಕೈ ತೆಗೆದುಕೊಂಡು ಹೋಗ್ತಾರೆ. ನಾನು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ ನಂತರ 7-8 ಬಾರಿ ನಿಲ್ಲುತ್ತಾರೆ. ಫ್ರಾಕ್ಚರ್ ಪೈನ್ ಜಾಸ್ತಿ ಆಗಿದೆ. ಪೈನ್ ಆ ಕಾರಣ ಸಾರಿ ಕೊಟ್ಟಿದ್ದರು. ನಾನು 3 ಪಾಠ ನೋಡಿಲ್ಲ ಅಂತ ಸರಿಯಲ್ಲ. 3 ಪಾಠ ವಿಕ್ಟೋರಿ ಆಸ್ಪತ್ರೆ ನಂತರ ನನ್ನ ಕ್ಲಿನಿಕ್ಗೆ ಬಂದಿಲ್ಲ ಅಂತ ಸರಿಯಲ್ಲ. ಅನುಕೂಲ ಆಗಿಲ್ಲ. ಪದ್ಧತಿ ಪ್ರಕಾರ ಮಾಡಿರ್ತಾರೆ. Second, there is a delay in giving complaint. 3.5 minutes. Second, the vehicle has not been seized by law. 3rd point.
Auto is not seized.
No, vehicle has not been seized. I know any vehicle has been produced.
According to him, that is some auto, Allah.
Yes, my lord. And it has belonged in the same area.
So there is no FIR.
Where is there, my lord?
unknown.
Delay you apply.
No, in that FIR, the auto number is mentioned.
Yes.
54 days, my lord.
So that auto is not seized.
No.
So
Yes, my lord. Charge sheet has been filed.
Charge sheet has been filed, my lord.
Ah.
Here, very charge sheet is not.
So what happened to the criminal case?
I think they were guilty.
I think ಅಂದ್ರೆ assumption.
In the case of injury, he died after the lapse of, there is no second FIR. After the death, they should intimate to the police that he was dead due to the accident and they should take second FIR.
ಮಾಡಿಲ್ಲ. Whether they have seized the vehicle.
Yes.
IMB report ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ ನಾನು ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಸರ್ ಅದನ್ನ IME ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ.
ಓಕೆ.
FIR, ಚಾರ್ಜ್ ಶೀಟು, ಸ್ಕೆಚ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಏನು ಮಾಡಿದ್ದಾರೆ?
ಅವ್ರ ಮೇಲೆ ಆಟೋ ರಿಕ್ಷಾ ಡ್ರೈವರ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡಿದ್ದಾರೆ.
What is that offense?
Offense is
So take the date, my lord. And it has been filed.
ಅದು plead guilty ಮಾಡಿದ್ರೆ 134, 187, 279, 338.
338 madam.
Then why he has not been prosecuted for 304?
Subsequent death, it has not post-mortem agil, sir. It was not intimated to the police also.
Conveniently don't do anything. Collude with the opposite side. Offending
No, my lord. The collusion is to be proved by the respondents. Cannot be presumed, the presumption.
Why is the delay in lodging the complaint?
Complaint is not, it is not our duty, my lord. It is the duty of the police to register the case. It is a state. To a complainant should be the state.
Was to give the information.
No, my lord. There are so many decisions of our own High Court and also the Supreme Court. The delay is not a ground for the rejecting the claim petition.
Get some intuition that you are met with an accident.
Yes, my lord. The intimation has been given to the police. Police should have been examined.
And have you given the intimation?
In the exhibit P5, my lord.
Please answer the question. See the date and tell me.
I have not given the complaint. Complaint has been given subsequently after 24 days, my lord. The reasons have been given in the complaint also why it has been delayed, my lord.
From the police station. First time.
Yes, my lord.
First time when it is informed to the police station.
It was informed from the doctor, my lord. First time. On the same day, accident day. It is at exhibit P5.
Sir, Vishwendraya, the incident which has happened on 6/12/2016.
Yes, ma'am.
There is a complaint early. He has gone to the clinic on the same day. Exhibit P5. He's gone to the clinic on the same day. There it is recorded. There's a fracture of the right hand and femur. Abrasions, bleeding on the face. On the right side. Previous injury to the orthopelvic region. Refer to major hospital for treatment. Further procedure.
They never say. in 2016.
Huh? Yeah, vehicle. Owner ಬಿಡ್ರಿ ಇವಾಗ why you are concerned about the owner? We are concerned about the person who has died. He has immediately gone to the private clinic. Fracture of hand is there. Head injury, though there is no head injury. Grievous injury is reported. Early. Let us assume even if it is hit and run case, after that there is a FIR filed. Even if it is hit and run and later on he has realized. Why you have not got it verified through the medical board whether this septicemia can be caused with the injury suffered like this? I'll refer to the medical.
Yes. I may kindly be given one date, my lord. I will convince all those things, and also I will produce some other decisions also.
I will refer it to the medical board to find out an analysis by the experts of the septicemia, whether this can lead into death because of the injury suffered.
Yes, it will lead into death, my lord. It is a septic. Yes.
Doctor. Yes.
Our own High Court has held in the same, decision. There is a decision, my lord.
For some time. And on perusal of the records, including Exhibit P5, which is the first document of reporting the accident on 6/12/2016, wherein it is mentioned in the Dhanvant clinic by the doctor that history of accident hit by auto in causing fracture of right hand and femur and abrasions and bleeding on the face. Thereafter referred to Victoria Hospital on the same day, that is 6/12/2016. The deceased was aged 70 years. As per the medical certificate issued by the private clinic doctor who's examined as PW.
Three.
It is stated that the cause of death being multiple grievous injuries with third degree of septicemia, giving rise to multiple organ failure and death. There is no postmortem conducted. Death certificate is produced as natural death. In view of this court deems it appropriate to refer this matter to the medical board of the Victoria Hospital, Bangalore, to give a report with regard to the injuries sustained by the deceased as on 6/12/2016, as mentioned in Exhibit P5 and P6, whether it could lead to the death due to the occurrence of the injuries sustained in the accident. The registry shall place the records before the medical board, the Victoria Hospital, as mentioned here and above. The report shall be submitted within 2 weeks. On submission of report, list this matter before the court. In such cases, you should get it referred to insurance company. You ಮಾಡ ಕೆಲಸ ಮಾಡಲ್ಲ. ನಮ್ಗೇನ್ ಗೊತ್ತಾಗಬೇಕು. Septicemia ಅಂತ the doctors are also very as vague as possible. You see the definition of septicemia, it is the bloodstream leak of the bacteria in the blood. Whether it has happened after that due to something else after the accident, it has to be expert only can provide us the information. After 2 weeks. In the meanwhile, you can take some opinion. You can take some opinion yourself based on these documents. You're a mighty insurance company. Don't refer to your doctors, whoever you know. Give them an opinion and see whether they are giving a proper report. You know how the government hospital give report. ನೀವು ಮಾಡ್ಬೇಕಲ್ರಿ ಅದು ಅವ್ರು ಯಾಕೆ ಮಾಡ್ಬೇಕು you should examine according to him he has already produced P6 which says that septicemia due to the injury. If that report comes, then I will dictate. What is the question of remanding for what? That the tribunal is not an expert. Now it is only whether the occurrence of accident is not in dispute. That he has reported. Reporting to the police station, delay in filing FIR is no ground. Even if it is to the nearest clinic, date of 6/12/2016 is not in dispute. Even Victoria Hospital is same, 6/12/2016. No. There is a, no. In that self-fall anta ide, but again there is a, here it is first report is history of road traffic accident hit by auto. There that self-fall is added on top, oneself. We don't know whether that is there in their records. There is no MLC. Because they thought probably we will become all right. So find out whether they have recorded any MLC. No, 58. Rangi ready. Ready now? Both of you are ready. Employees compensation.
Yeah.
Is it injury or death? So you are for the claimant?
So I am claiming. It's a one of.
So no insurance? So entire liability is fastened on you. Are you denying relationship?
Yes. He denied the relationship. According to the provident fund officer, this percent judiciary is was required. According to the provident fund employee, tendered in the he was paid the provident fund to the employee.
And what is the document?
Yes, sir. But
reconstruction as a site engineer. Remove the construction of all existence.
there is a complaint.
Both the learned counsels are present before the court. Due to paucity of time, they will file a lot. No, list this matter next week.
Tuesday.
7. List on 7.
8.
List on 8.
Only that reason. But the Washington judiciary is required, detailed inquiry report is there. I produce.
In
Thank
See,
you.
in Employees Compensation Act, its simple thing is there should be a relationship of employer and employee.
Yes, sir.
It should have happened during the course of employment,
Yes, sir.
in the course of employment. That's all.
But I say judicial is retail inquiries to be conducted.
We'll see that, we'll consider.
Yes, sir.
59,
59.
Jagadish. None appears, we list next week.
62, Puttaswamy C.
Puttaswamy, injury case.
It is on today.
Ready? List on Monday due to paucity of time. Girisha,
63. Girishana,
second appeal, permission to file and represent appeal filed by advocate for appellate. We list next week. We list next week.
54. Dorapati,
Yes, Nagaraj. Due to paucity of time, we list next week.
66. Sri Prakash,
Sri Prakash. Yes, sir, yeah. Both of you are waiting for quite some time also. Ready, Ibro ready. In declarations.
Declaration and then we must appeal before them sign a
Converts it to partitions. So you are plaintiff or defendant? So what happened in the trial court? Declarations. The parties are related? Related? Why don't you settle the matter? Any of the properties? What are the properties involved?
So, release it, partition, 50 years.
But you explored possibility of settlement? No, if you have already explored, it is not possible, then you can address arguments and we can pass an order. If there is still possibility, so that you can settle and still maintain a good relationship, it is always welcome.
May I request also the beginning date of 19,
Yeah,
beginning from 19.
I will post it on 21st. In the meanwhile, you can sit across.
Something precise.
If you can work out something, well. Otherwise, you can argue on that. Both the learned counsels are present before the court. However, due to paucity of time, list this matter on 21st. Ready, there. What about the other side? 63. Just on 22nd. Take it on 15th. 15th.
7.
Pramod.
Is where the defendant sells the property to me, the registered sale. There are 15 positions. And when a locker permission says, both of them, he breaks open the lock and enters into position. Then a file is for declaration and position that has been seen and confirms with the employer.
He files a suit.
I file a suit against him.
You get an order.
That has been decreed.
In your favor. So concurrent finding.
The defendant himself is to enter.
So he's now still in possession.
After I take possession of the property, I keep the premises that block.
No, that's okay, that I've understood. Once you come back, he breaks in, gets inside.
He's in possession even now.
That's what. So despite you are succeeding, you have not been able to get into position. The stay is granted.
Earlier, this one was then they file an application for restoration.
Question of law is framed. Release this matter. Have it on 20th? 20th.
5 minutes.